Um, I'm Sally Ryder, and on behalf of the Rehnquist Center, welcome to the college's annual Constitution Day program. I'm going to give a brief introduction of the panelists and participants, and then turn it over to the moderator, Professor Marcus. I'll start in the end. Professor Ronell Anderson-Jones is a former newspaper reporter and editor who's now a professor of law and associate dean for academic affairs and research at BYU Law School, where she teaches constitutional law, First Amendment law, media law. Prior to teaching, Professor Jones clerked for Judge Willie Fletcher on the Ninth Circuit and for Justice Sandra Day O'Connor on the U.S. Supreme Court. This is sort of a welcome home for Ronell. She taught here for 4 years as a distinguished faculty fellow before moving to BYU. So welcome back to Ronell. Next to Ronell is Judge Murray Snow, who sits on the U.S. District Court for the District of Arizona, Phoenix. He was confirmed by the Senate in 2008 to a seat vacated by a good friend of the law school and an alum, Steve McNamee, who took senior status. Prior to being named to the district court, Judge Snow served on the Arizona Court of Appeals in Phoenix and also worked in private practice. And I learned today he also clerked on the 10th Circuit, but I don't know the judge he clerked for.
Stephen Anderson.
Stephen Anderson on the 10th Circuit. It's the first time Judge Snow has participated, so thank you very much.
Thank you.
Next to Judge Snow is Professor Ilya Solman, who's a professor at George Mason University Law School. His research focuses on constitutional law, property law, and political participation. In addition to teaching at George Mason, he's been a visiting professor at University of Pennsylvania Law School, and he's also taught in Germany, Argentina, and China. After law school, he clerked for Judge Jerry E. Smith of the U.S. Court of Appeals for the Fifth Circuit. You can see a pattern here of all these law clerks, a great job, something that all the students should think about applying to do. And finally, our moderator is Dave Marcus, who is 1885 Society Distinguished Scholar and Professor of Law here at the U of A. He teaches civil procedure and is an expert on complex litigation and class actions. Prior to teaching, Professor Marcus clerked for Judge Eileen Ross of U.S. District Court for the Eastern District of New York, and also clerked for Judge Willie Fletcher on the Ninth Circuit. He worked in private practice, and Professor Marcus does a lot more than just moderate this program. As you'll see, he really enlivens the discussion and sets the stage for each case with astute analysis and thoughtful context to stimulate the discussion. And I thank Professor Marcus for being so willing every year to do this, because I think it really makes our Constitution Day program. So, Professor Marcus.
Well, thank you all for coming. I have to apologize, especially to Dean Ryder. I was so engrossed in the nuances of the Affordable Care Act just now that my wife, Nina Raven, professor at this law school, had to bring me out of my office and remind me that this was beginning. I'm not joking. I was trying to parse together this statute that is the basis for our first case today. Thank you all very much for coming on this very rainy Monday here in southern Arizona. It's a real delight to participate again in these Constitution Day exercises. And I am really grateful and humbled to be part of a discussion with such august commentators as we have here. So I'm very grateful to Professor Soman, to Judge Snow, and Professor Anderson-Jones for coming and visiting us here in Tucson to participate. There's a lot to be said about the Supreme Court's term this past term. It's quite an extraordinary one. But because of my tardiness, I think we'll get straight to the first case, which is King versus Burwell, right?
Yes.
Great, okay. Our first case, King versus Burwell. So I'm going to present some summaries of the case and try to speak for about 10 minutes for each case, and then I'll turn the floor over to our distinguished guest. Karl Marx famously wrote that history repeats itself. The first time is tragedy, and the second time is farce. These words, depending upon your perspective, perhaps describe King v. Burwell, a farcical progeny of the colossal NFIB v. Sebelius. NFIB v. Sebelius decided in 2012 upheld a centerpiece of the Affordable Care Act, known as Obamacare, against a great constitutional challenge and is perhaps the most significant decision on structural constitutional law of the last 20 years. King v. Burwell, decided this past June, also upheld a key plank of the Affordable Care Act, but this time the case turned on an issue of statutory interpretation so silly that only a lawyer could take it seriously. To understand this opera buffa, one needs background into the design of Obamacare and the political dynamics that produced it. First, the design. Much of Obamacare rests on what's called a three-legged stool. The first leg is the statute's requirement that health insurance companies do not discriminate based on pre-existing conditions. Obamacare wants people who need health insurance to get it. But insurance companies don't want to insure sick people. In the past, they refused to sell insurance to people who had pre-existing conditions, precisely the people who most need health insurance. So Obamacare requires insurers to sell their products without regard to someone's pre-existing conditions. So this is the first piece of the puzzle, but this first leg creates a problem. What keeps someone from waiting to buy insurance until that person is at the hospital door and already deathly ill? Insurance only works if insurers can use the premiums that healthy people pay to cover the costs of treating the sick. The rational person after Obamacare should wait until she gets sick, that is, until she's at the hospital door, and then to call an insurance company and buy health insurance. Why pay for other people's insurance while you're healthy? Unless healthy people are forced to buy insurance, Obamacare would either force insurance companies to exit markets or to charge sky-high premiums for insurance. So Obamacare's individual mandate solves this problem. It's the stool's second leg. This is the requirement that everyone has to have insurance or pay some kind of penalty. Okay, but this second leg creates yet another problem. Health insurance can be too expensive for people. Hence the third leg of the stool, a subsidy in the form of a tax credit for people under a certain income level. This is the three-legged stool, so-called because if you kick out any one leg, the whole stool will collapse. If not for the individual mandate, the provision prohibiting discrimination against people with pre-existing conditions would cause insurance markets to collapse. If not for the subsidies, the individual mandate would fail. The Affordable Care Act had to deal with one more problem. A problem in an insurance market is that it's fairly easy for insurance companies not to compete with each other. Prices may therefore be super competitive. The solution is to create online exchanges where companies would be forced to compete. On these exchanges, people of limited means, using tax credits, can afford insurance. But here's yet another problem. Which government would create these exchanges? The House bill that was the basis for the Affordable Care Act said that the federal government would set up a single national exchange. But some centrist senators balked at the idea of the federal government providing a single exchange. They thought it might be a stalking horse for a single federal public option where the federal government take over of healthcare entirely. So their political solution was to have each state set up an exchange. This solution created yet another problem. What if a state refused to set up an exchange? Well, the Senate bill had a backstop. It provided that the federal government would come in and provide an exchange for a state that opted out. So the House bill and the Senate bill differed. It was thought that differences would be ironed out, and that each house would pass some marked up version of the bill, and everything would be ultimately reconciled, the usual process of legislation. But things took a turn against this sort of smooth process from happening. Ted Kennedy died. So when Ted Kennedy died, Scott Brown scored this triumph victory in the liberal enclave of Massachusetts and won an election to the Senate, depriving the Democrats of their filibuster-proof majority. So the Democrats in the Senate could not pass any other version of the bill than they had already passed. The only way to get Obamacare was for the House simply to pass the Senate's bill, without the kind of tinkering and revision that you otherwise would have in legislation. In a very simplistic way, this is essentially what happened. Now, this political train wreck produced Kane versus Burwell. In May of 2012, 1 month before the Supreme Court upheld the individual mandate leg of the stool as constitutional, the Internal Revenue Service promulgated a rule regarding the subsidy leg. The rule provides that someone is eligible for a tax credit, that is the subsidy, if he buys an insurance plan through an exchange, whether established by a state or by the federal government. Now, it's important that this rule extended subsidies to those buying insurance on federally created exchanges, because ultimately 34 states opted out of the exchange creation obligation, and 8 million people are therefore buying insurance on federally created exchanges. The IRS rule was the moment a couple of lawyers were looking for. Digging through the steaming entrails of the Affordable Care Act, they stumbled upon an interesting and obscure provision, Section 36B. Section 36B provides that the amount of a tax credit a person can receive depends in part on whether the taxpayer has enrolled in an insurance plan through, quote, an exchange established by the state. These two lawyers had this eureka moment. Exchanges created by the federal government for the 34 opt-out states were not exchanges, quote, created by or established by the state. The plain text of the statute therefore did not extend subsidies to people who bought insurance on federally created exchanges. The IRS rule providing otherwise conflicted with the statute and as such is unlawful. Now these two lawyers thought they had identified a way to kick the individual subsidy leg out from the three-legged stool. If the 8 million people in the 34 opt-out states couldn't get subsidies, they wouldn't be able to afford insurance. If they didn't buy insurance, insurance companies wouldn't have the pool of healthy people to spread risk across, even as they are required to sell insurance to sick people. Insurance companies would either exit the health insurance market or would charge sky-high premiums. Obamacare would lie in shambles and miserable failure, all because of these few words in Section 36B, established by the state. These lawyers found a couple of plaintiffs, brought some lawsuits, and ultimately took the case to the Supreme Court. So here's the issue. Section 36B extends subsidies to people who buy health insurance from an exchange, quote, established by the state. The IRS issued a rule extending subsidies to people who buy insurance on exchanges created by the federal government. Is the IRS rule permitted by the statute? Well, in a 6-3 decision, the Supreme Court said yes. Writing for the majority, Chief Justice Roberts reasoned that the phrase established by the state can include exchanges created by the federal government for opt-out states. Roberts' opinion is dense, parsing the details of the Affordable Care Act as if it were sections of the Talmud. The gist of the opinion is this: if we were to read the phrase exchange established by the state to exclude federally created exchanges, a lot of Obamacare doesn't make sense. For example, the statute says that only, quote, qualified individuals can buy insurance policies on an exchange. Qualified individuals is defined as those who, quote, reside in the state that established the exchange. For the 34 opt-out states, the federal government established the exchange. This means that in these opt-out states, there are no qualified individuals if we read the phrase state that established the exchange to exclude federally created exchanges. In other words, no one would be eligible to buy health insurance on the federally created exchanges at all. This is an absurd result. It's not a great term that Chief Justice Roberts uses, but that's essentially where he's aiming at. Chief Justice Roberts concludes that the phrase established by the state is ambiguous, so then he looks to what he calls the broader structure of the Act to figure out whether the IRS interpretation is plausible. He points out an obvious fact. If subsidies aren't available to the individuals in the 34 states where the federal government created the exchange, then one of the stool's 3 legs disappears. The whole system created by the Affordable Care Act would collapse in most states in the country. Why would Congress create these federal exchanges, only to have them be totally useless at stopping this health insurance death spiral? To quote the Chief Justice, Congress passed the Affordable Care Act to improve health insurance markets, not to destroy them. If at all possible, we must interpret the Act in a way that is consistent with the former and avoids the latter, the Chief Justice concludes. Justice Scalia wrote the dissenting opinion, and it's a real doozy. It sort of takes the temper tantrum of a dissent to its ultimate level. Scalia's dissent marks only the second time in the history of the Supreme Court that the term applesauce is used in an opinion, and the first time that the phrase jiggery-pokery appears. What's going on here? Justice Scalia thinks that the Chief Justice is driven by one motivation only, to preserve Obamacare at all costs. But I wonder if something more profound is afoot. No justice has had more influence on the reading of statutes than Justice Scalia. His method is one called textualism. We focused on the text of the statute to the exclusion of everything else. If the text leads us to improbable results, well, that's Congress's responsibility. Textualism has largely succeeded in banishing more purposivism-driven arguments about how to interpret statutes to the dustbin of legislative interpretation history. But textualism is problematic because it's often wooden and formalistic. Chief Justice Roberts' approach here and a few other opinions is more pragmatic. Building from the scraps of old purposivism in statutory interpretation, the Chief Justice offers us a method that respects text but is also attentive to reality. The reality here, as the Chief Justice notes, is that Congress is broken, that there is no congressional response. The tortuous path the Affordable Care Act followed to its passage confirms that this is so. In an age where our national legislature is so sclerotic, the court must give effect to the best possible reading of the statute within plausible textual limits. Okay, I believe Professor Anderson-Jones is our first commentator on this one.
You want me here or there? Here. Okay. So thanks very much to Professor Marcus and to Dean Ryder and to the Rehnquist Center for inviting me. It is really, really great to be in a place that still feels so much like home to me. And it's especially a treat to be able to talk about this particular case, which is surely being added to the next edition of every single legislation and statutory interpretation casebook on the market as we speak. And it's a treat in part because I got my start in legal academia teaching legislation and statutory interpretation here at the U of A. There are, I think, at least 3 ways that this gem of a case is going to light the legislation and statutory interpretation world on fire. And I want to save some good time for a wider discussion of each. So just let me say a few words about each of these 3 ways. They are, first, the question of what this case says about Justice Scalia's wider textualist revolution. Second, the question of what this case says about the roles of the canons of interpretation. And third, what this case says about the ongoing vitality of the Chevron doctrine. On the first of these points, Justice Scalia's dissent, which I think Professor Marcus correctly identifies as a tantrum, it is full-on apoplectic. And it takes direct aim at the majority's contextual purposive approach to the statute. He's very, very angry that the majority is looking to the, quote, legislative plan to try to understand how to read statutory language. Scalia, whose rhetorical stylings in recent years have included accusations that his colleagues are tutti-frutti and that they speak in argle-bargle, throws in a bunch of gems in this case, the jiggery-pokery and the pure applesauce. He jabs that we ought to call it SCOTUS care instead of Obamacare. He at one point says, now they've done it, words have no meaning. So he's sort of taking some fairly personal or at least very direct jurisprudential stabs at his colleagues. But what's most telling, I think, doctrinally about this dissent's pushback is how really adamantly it's trying to assert that the majority's opinion, quote, changes the usual rules of statutory interpretation for the sake of the Affordable Care Act. So he's accusing the court of treating the ACA like a favored child for the second time, for bending and stretching the jurisprudence to try to uphold it. And I think it's not surprising that Justice Scalia wants to paint this method of statutory interpretation as an aberration confined to the ACA, because the other possibility on deck here is that as a much more frontal attack on one of what, as Professor Marcus notes, is one of the most important parts of Justice Scalia's arguable legacy on the Supreme Court, this rise of textualism in statutory interpretation. There's a lot of interesting commentary out there about just how much of a departure this case is or isn't from what the court has actually been doing for a long while in statutory interpretation. And some folks are suggesting that the answer is that textualism never really did take hold at all because the court has only ever really engaged in it without much resort to context when the stakes are just not that high. But we can certainly understand why Justice Scalia's rhetoric is so heated in his dissent. A case that decides that established by the state actually means established by the federal government, and that turns to this wider context of the statutory scheme to generate ambiguity in that language, rather than just to resolve that ambiguity, is quite far afield from Justice Scalia's preferred approach. Justice Scalia has long asserted that Congress gets to enact into law through bicameralism and presentment actual words, not some wider purpose or legislative plan, and that the consequences when they enact words that have an inconsistent or unexpected or stupid result is that the court, through what you might call constitutional tough love, just forces them to live with that result or to use bicameralism and presentment to change those words that don't, to come to something that doesn't lead to that result. Justice Scalia angrily asserts that Obamacare moved his colleagues to an exception from this principle. But I think that's mostly because he hopes to high heaven that it isn't just their ordinary view of the court's role of interpreting and applying Congress's word product. Secondly, as a statutory interpretation case, I think King is notable for its paucity of dialogue about the traditional canons of interpretation. Anyone who has spent any time looking at statutory interpretation cases that make it all the way to the Supreme Court will tell you that there's very often a battle of canons and counter-canons, rules that say we usually read these sorts of linguistic phrases in these ways, or this linguistic situation has this interpretive result. My friend and former co-clerk Abby Gluck at Yale Law School has written really smartly on this question, and she's right that for better or worse, these canons have really become the currency of statutory interpretation litigation. But that's not what's happening here in King, and it's notable. In fact, really the only canon that the majority even sort of invokes is a canon that they say says that statutes should be read in context, which is not really so much a canon as an interpretive approach, and one that the dissenters really hate. To the extent that it engages in the other traditional textualist canons, it's only to briefly explain why they don't apply or why they aren't backed by legitimate assumptions about Congress when there's a statute that's as massive and as complex and as hastily drafted and as multifaceted as the ACA. For example, the majority totally brushes aside the argument that this reading renders that key language established by the state to be surplus, noting that the canon against surplusage is not an absolute rule. And so the implication seems to be that while we've often assumed that these traditional canons help us get at statutory intent, maybe that isn't true of many modern complex statutes that are, in the majority's words, inartfully drafted, which is, of course, the understatement of the millennium. But I think that when we hold this case up against virtually every other major statutory interpretation decision in recent memory, the court's willingness to completely sidestep some of the most common tools of the trade is certainly worth our attention. Thirdly, and finally, a really interesting thing that I just want to note about this opinion is that a relatively straightforward way for the majority to have gotten to its same result would have been for the court to invoke Chevron deference, to say that the phrase established by the state was ambiguous, and therefore that the court was bound to defer to the reasonable interpretation of the phrase that was given to it by the relevant agency, here the IRS. Chevron tells us that where there's statutory ambiguity, we assume that Congress intended the pertinent federal agency to fill in the gaps. Instead, though, the court here held that because the question in this case was of such, quote, deep economic and political significance and so central to the statutory scheme, if Congress had intended to delegate the power to the IRS to fill in the relevant statutory gaps, it would have done so explicitly. Now, Chief Justice Roberts' only question at oral argument in this case, literally the only thing he opened his mouth to say, was about this Chevron issue. This idea that there might be some kind of limitation on Chevron's applicability when the court finds a so-called important question or major question. Now that notion really seems to be gaining some traction at the court, and it was, I think, the same basic approach that the court took in Brown and Williamson, a recent case involving tobacco regulation. And indeed, a number of justices have sent signals in recent cases that suggest that Chevron itself may be on the chopping block, or at least that its glory days are largely over. And if true, that's not only noteworthy, but also raises the possibility of upending a great deal of doctrine from the last 3 decades. And I think that's something that we're going to want to keep our eyes on. All told, this case, which I think Professor Marcus is right, almost no one foresaw, outside of the very smart conservative lawyers who cleverly conjured up this suit, that basically, if we're being pointed, this involves people arguing that they are not entitled to tax credits, right? So it's a very careful, interesting litigation approach. But it ended up bringing us a very interesting and I think potentially far-reaching decision about the approach that goes on here, the approach that the court takes when it is asked about the meaning of a statute. And far beyond the political fodder that the case quite expectedly provided, I think it's worth our attention for the cases, for the ways that it generates questions about boundaries and tools and ramifications of statutory interpretation by the judiciary. And I'm anxious to hear the thoughts of the other panelists and of all of you. Thanks for your time.
If I'm next, I guess I want to talk a little bit about Justice Scalia's dissent, and I think for what it might highlight about the internal politics of the court and a difference in the interpretive doctrine that Justice Scalia has, I think, been so influential in getting the courts to adopt. If you look at Justice Scalia's dissent, he's basically saying any idiot can tell the difference between the state government and the federal government. And then he uses a rather interesting but probably not very persuasive example. He uses the election clause. The election clause of the Constitution. And the election clause of the Constitution points out that state legislatures get to pick the times, places, and manners in which congressional elections are held, except for such regulations as are made, and exceptions as are made by Congress. And in that dissent in King versus Burwell, he says, would anybody say that a federal election law and a state election law are in all respects equivalent? Of course not. Now, you might wonder, why would Justice Scalia use a constitutional example in a statutory interpretation case? And the reason was, of course, is that Justice Scalia knew something that something would happen that none of us knew at the time. King versus Burwell was decided on June 25th, 2015. The dissenters were Scalia, Thomas, and Alito. On June 29, 2015, Arizona Independent Redistricting, or the Arizona Legislature versus the Arizona Independent Redistricting Commission case came out. And the dissenters in that case were the same three, but the dissent was not written by Scalia, it was written by the Chief Justice. And the dissent, if you take out the invective, in the Arizona Legislature case is structured almost exactly the same as the dissent in King versus Burwell. It goes through the Constitution and looks at all the times that legislature is used that couldn't possibly mean anything other than legislature, just like the King versus Burwell dissent goes through all the instances in the statute in which state is used and says the only possible meaning this could be is state. Well, what is Justice Scalia doing then by invoking the Elections Clause? He is jabbing a finger at Justice Roberts and saying, you are terribly inconsistent because I know that in 4 days we're going to issue a decision in which you have followed this exact same analysis on my side of the fence. Why aren't you doing it in the statutory interpretation case? And I think that is an interesting question because I'm not sure he's been consistent about this, and I'm not sure he would claim consistency, but his textual approach has been one that at least to me is in large measure persuasive. I mean, the law is what the law says it is, and when I am called upon to interpret legislation, and let me just say that after having spent years interpreting state legislative enactments, and now having interpreted congressional legislative enactments, they're all a mess. They are very, very hard to interpret, and you have to use some interpretive principles. And if you're going to make any legislation workable without sending things back to Congress all the time, you have to engage in some you have to engage in some sort of interpretive principles to come up with what things mean. And I'm sorry, I'm the only judge on the defense panel. I defy anybody else to tell me differently. You haven't had the experience. But if we were going to ask Justice Roberts, Chief Justice Roberts, is there really a principal distinction in what Scalia is accusing you of being vastly inconsistent? Is there a principal difference in your interpretive approach? I think one of the things that Chief Justice Roberts might say is there ought to be a difference when you're talking about statutory interpretation and when you're talking about constitutional interpretation. And that is because, I suppose he might say, and this is all speculative, if we interpret a statute incorrectly, Congress can always revise our interpretation merely through legislation. Whereas if we interpret the Constitution incorrectly, it's going to require a constitutional amendment. And so it is in the nature of our job and the fulfillment of the practical and political function which we serve, completely appropriate to give more leeway as to what legislative intent might be or legislative context in engaging in the exercise of statutory interpretation. I don't know what else he might offer, but I suppose that might be one principal basis he would offer. And then that poses a different question that I think Professor Marcus teed up. And that is Congress so broken now that it can't even correct something it passes? Can we really reasonably expect Congress to pass laws when the Supreme Court interprets them in a corrected manner, or is it so broken that it can't? Is it so broken that it is as difficult to obtain corrective legislation as it is to amend the Constitution? I think almost all of us would say no, but if we are engaged in the world of real politics, is it as difficult to obtain corrective legislation as it is to change one or two justices' minds about what the Constitution means? And I'm going to have some observations later about part of the interpretive approach that I think is very problematic, that seems to have taken over the court, is this idea that stare decisis means very little. And if that is in fact the case, I think it has some ramifications for both the legitimacy of the Supreme Court as a political institution, but also as a legal institution, that are worth thinking about. And I think all of that has been highlighted by Justice Scalia's subtle poking at Chief Justice Roberts, saying you're inconsistent when it's statutory interpretation and when it's constitutional interpretation. And I think it's something we all ought to consider.
So I have a slightly different perspective on the case from some of the ones heard previously. I think it's a tough case where both sides have some good arguments. It's one of the reasons why I decided I wasn't going to be involved in this case in the way that I was involved in NFIB versus Sebelius, the more dramatic, and in my view and yours, predecessor to this case. Nonetheless, ultimately, the more I think about the matter, the more I feel like the Supreme Court came out the wrong way. And I'll briefly describe why. First, I do not in fact think that the phrase established by the state is ambiguous. It pretty clearly says state rather than federal government. If you want to view the words in context, the statute often uses federal government, or worse to that effect, when they mean federal government, and they use states in other contexts. So it's not by accident that the word state is used here. And for many decades, not long before Justice Scalia joined the court, by the way, the Supreme Court has had precedent on the book stating that there's a strong presumption in favor of following the text when the text is clear. Now, I'm not a pure textualist. I don't think that presumption should be quite as strong as perhaps Scalia thinks it is, but I think at the very least a good deal must be there to overcome the presumption in favor of following the text. I think ultimately we don't have enough to overcome it in this case. To understand what happened here and why reading established by the state to mean state makes sense, it's important to understand the political context in which the statute was enacted. At the time, there was very little discussion of what would happen if many states refused to set up exchanges, and this was so for a couple reasons. One is that the supporters of Obamacare, and by the way, even many of the opponents as well, including myself, we all thought that Obamacare was going to be much more popular than it turned out to be, and therefore the expectation was that states would have strong political incentives to adopt these exchanges. Moreover, if the political incentives were not enough, there would be the stick of not getting subsidies, and that would give them additional incentive to create the exchanges, even if otherwise they might have been on the fence about it. This is not just my idiosyncratic interpretation of the way this was supposed to work. This was repeatedly stated by no less than Jonathan Gruber, the MIT economist who was the principal policy architect of Obamacare, and also, by the way, also of Romneycare before it, the Massachusetts state statute pushed forward by Governor Mitt Romney that later served as the model for Obamacare. Ironic that the two of them, Romney and Obama, later opposed each other in the 2012 election when they were the two people so much responsible for Obama's most important policy. So in the years after the act was enacted, Gruber made multiple speeches urging states that they had to adopt these exchanges, otherwise their citizens would not be eligible for these subsidies. Now, I'm not claiming that Gruber's view by itself definitively proves what the right interpretation of statute is. That would be wrong. All I'm saying is that the fact that he thought this, and he was the leading expert on the subject on that side of the issue, is a sign that it's not absurd to treat it this way, and it's an extra argument for why we shouldn't try to go against the plain text in this case. Now, obviously, the political expectations that all of us had, many of us at least, turn out to be wrong, and obviously also the states didn't heed Gruber's warning, but that's a flawed political expectation. It doesn't mean the statute was absurd, it just means that it was based on political calculations that turn out to be wrong. Now, the majority opinion, and many others who support it, they say, well, you still have to interpret it to allow it to be the federal government, because otherwise there would be a catastrophe, the statute wouldn't work well at all, and it would be horrible, Congress won't fix it. I do recognize in this scenario it wouldn't work out exactly as the supporters of Obamacare envision. However, it's important to understand that if there's a state where people are not eligible for these subsidies, the people in that state are also exempt from all or most of the employer mandate imposed in Obamacare. That is, employers are not required to provide the kind of health insurance required by Obamacare, and also they're at least partially exempt from provision of the individual mandate, which means, by the way, in those states, had things worked out in that way, if you like your previous health insurance, then you would actually have a good chance of keeping it. So there's a trade-off here. States wouldn't get the subsidies, but they would also be freed from many of the mandates of Obamacare, and as Amicus briefs from many states indicated, in the King versus Burwell case, there's quite a lot of states that would be willing to take that trade-off. They would have less of Obamacare's subsidies, but also less of its mandates. That means, among other things, that people could buy health insurance plans which are cheaper and more flexible than those that Obamacare allows. All of this, I think, means that this way of working the statute, while it may not be the best possible way, you can debate about whether it's good or not, it's not absurd. It is reasonable. It gives states, in effect, a choice between getting the subsidies and mandates or having neither. And states would have that option, as indeed they do with many kinds of federal programs. And so you can see a world here where Obamacare may not be working perfectly, but the world is not ridiculous and dysfunctional. Many states would actually prefer it to be that way than to be the other way, and this further strengthens the case for not overriding the taxpayer. I think lastly, very briefly, I would mention it's not entirely clear to me how much of a precedent this sets for future cases. I think it's significant, as I think Rennell pointed out, that they didn't engage in Chevron deference here, even though they could have. That's, I think, a precedent for future cases, a good one in my view. To what extent will the Supreme Court be willing to sort of restructure and reinterpret other statutes like it did with Obamacare? In this case, well, it's hard to say, because I think part of what motivated the majority is the sense, well, this is a really important statute and it needs to be given a chance to work the way that its supporters envisioned. They might not have that strong a sense for a less important law, but to my mind, I think that's not an unreasonable way of looking at things, that you should be extra careful with really important laws. But I think it's also reasonable and ultimately better to say that if an important law is based on flawed political expectations, that doesn't mean the court should give the law a break. Rather, they should let Congress and the president work together to fix it. If there's gridlock, that's not an excuse for the court to try to fix the problem themselves. Indeed, gridlock is deliberately built into the system, and often it serves useful functions. So on that note, I conclude, but I really look forward to the rest of the discussion of this.
Okay, we have about 7 minutes left in our King v. Burwell time period, so I think I'd like to invite a couple of questions from you all. If you could speak as loudly as you can so we can all hear it. Yes?
Yeah, I have two very quick questions. The first question is, using Scalia's rationale, would he be in favor of renaming the Secretary of State's position to the federal government? Because obviously the term state is used there, and it would be, under Scalia's rationale, very misleading.
I think here context is important in a statute which repeatedly use state to refer to states and federal government to federal government. The word state here is referring to state. Moreover, of course, the word state in Secretary of State is actually a different meaning of the word state. It's one that means functionary or the like. It's sort of an archaic meaning, whereas for a statute written in 2010, we wouldn't normally assign an archaic meaning. By the way, the word state in Secretary of State does not mean federal government. It means some sort of general governmental function.
Exactly. And that leads me to my next question. Did any of the justices address the rationale that, in effect, the federal government stood as a de facto assignee or de facto successor in interest to this issue, and that it didn't really matter whether the term state was used? If the federal government stood in the position of the state, they were de facto the successor in interest or an assignee, and therefore the term, whether it was federal government or state, really wasn't necessary.
So that exact storyline didn't come up from the government. Of course, the government did have to, if you're taking this case to the Supreme Court, right, and you're asking the Supreme Court to come to the conclusion that that established by the state can only mean established by the state and cannot mean established by the federal government, even though the federal government would be out there setting up what turned out to be the vast majority of them, you do have to come up with some storyline for why that's true, right? There has to be some storyline. And maybe the obvious storyline is Congress is sloppy, or makes mistakes, or wasn't careful enough. But that wasn't the only storyline that was engaged, and I actually think this was a massive litigation mistake. If you're thinking about what's going to happen with Justice Kennedy in this case. The storyline that got promoted here was actually Congress really wanted to pressure the states to establish these exchanges on their own, rather than to have the federal government step in and establish them, as it has now done in 34 states. And that argument, I think, is a very poor strategic choice when the challengers need to get Justice Kennedy's vote, and their proffered explanation is basically that Congress, without very much clear notice, in this kind of obscure provision, tried to pull one over on the states and sort of railroad them into doing something that they didn't realize was happening, and with this consequence that would be lurking in the background. That's not the sort of thing that the Federalist Justice Kennedy is going to be interested in buying into. And so maybe the better storyline was just Congress makes mistakes, and it's our job to be take a more active role in correcting those mistakes so that they're more consistent with the overarching statutory scheme. But that wasn't the litigation tale that was invoked in the briefing.
I think Professor Solomon addressed this to a certain extent in a very nuanced description of how the design, as described by the challengers, is not absurd. And I think I completely agree. I would wonder, though, why Congress would hide an elephant in a mouse hole in this way, especially as Professor Anderson-Jones suggests. You might run into a kind of state coercion type problem with Justice Kennedy. So that's the question. But Professor Solomon,
yeah. So I actually wrote extensively about this very aspect of the case before it was decided. It ended up playing virtually no role in the opinion. Indeed, interestingly, the word federalism doesn't even come up. Yeah, I think in the majority, and even in dissents also. And I think two things about this elephant in the mouse hole. One is, I don't think it was actually all that hidden. It's right there in the word state. That's not hidden. That's right there on the face of the statute. Second, why didn't they make a bigger deal of it? Because they thought Obamacare was going to be popular, and therefore there wouldn't be any need to consider what would happen if states chose not to establish these exchanges. They also, by the way, thought that the exchange would be easier technically to set up than they turn out to be. So that's another aspect of this. Nobody, myself included, expected what was going to happen with healthcare.gov, and that states, even liberal states, that try to set up exchanges run into problems doing so. So that's another aspect of it. On the state coercion aspect, it's true, there were numerous amicus briefs arguing that if you rule the way the challengers want, the states end up being coerced, right? That they're pressured by lots of these subsidies. I think this is an improper application of the Supreme Court's precedents in this area, all of which focus purely on conditional grants to state governments. They don't say that states can somehow be coerced by grants that are given or not given to individual citizens. But if you do want to go down this route, you want to say, well, we're going to judge coercion in actual practice regardless of these formalistic distinctions, and it turns out that the states are actually more coerced by the interpretation that prevailed than by the plaintiff's interpretation, because under the plaintiff's interpretation, states actually have more options. They can choose to accept the subsidies, but also then have their citizens be subject to mandates, or they can be freed from the mandates and not get the subsidies. On the other hand, under the approach that prevailed, states can in effect get a choice that isn't much of a choice at all. They can set up their own exchanges, and then they get both subsidies and mandates, or they can choose not to set up their own exchange, and then the exact same thing happens, except that there is now an exchange run by the federal government. So the approach to give states fewer options is actually, to my mind, more coercive than the approach to give states more. My own ultimate view is that the Supreme Court's coercion doctrine doesn't even apply to this situation at all, but if it does, it should have favored the challengers.
Okay, I apologize. We will have time for more questions as we proceed, I'm sure, but we do need to stay on track, and our next case we're right up at time for our next case.
Yes.
So our next case is Horn versus Department of Agriculture, right? Great. Okay, now I need to stress one thing before I get started with this case. I'm not making any of the following up, okay? So I need to stress this. Horn versus Department of Agriculture involves a challenge to the National Raisin Reserve. Again, I am not making any of this up. The United States has a National Raisin Reserve that's very useful in the case of a dramatic raisin shortage or some sort of nuclear holocaust involving loss of raisins. We have this National Raisin Reserve. The issue in the case is whether the takings clause of the Fifth Amendment permits the federal government to lawfully confiscate a percentage of a farmer's raisins in order to maintain a cartel of producers and keep raisin prices artificially inflated. Again, I am not making this up. I cannot do justice to this case. That's better than what Jon Stewart of The Daily Show has done. I urge you to Google Daily Show and raisins, and you'll find a wonderful presentation of this case. Now, a little New Deal history is needed to understand the plausible basis for the National Raisin Reserve. As everyone knows, Franklin Roosevelt took office at the peak of the Great Depression in 1933. Roosevelt was convinced that collapsing demand had caused our country's economic woes and was keeping the country from recovery. With 25% of the country unemployed, the people weren't spending enough money. The problem, he thought, was ruthless competition. Competitors within a particular industry were ruthlessly competing with each other, driving prices so low that companies were going out of business. When a company goes out of business, people lose their jobs, they lose their purchasing power, fewer products are purchased, more companies go out of business, and so forth and so on. The spiral goes on downwards. Now, to Roosevelt's mind, the solution were what are called codes of fair competition. Industry participants should organize to come up with codes that would regulate how they would compete with each other. These codes would set minimum prices, maximum working hours, and so forth, and would be legally enforceable upon paying a criminal penalty. Businesses would not compete each other out of business, employment would rise, and that would be great. Now, to any student of economics, the flaws in this plan are obvious. The Roosevelt approach basically created government-enforced cartels, keeping prices artificially high. Powerful industry participants basically crafted these codes to their own benefit and then used the threat of government sanction to force any less powerful competitor to march in line. Most of these codes died a well-deserved death in 1935 when the Supreme Court decided the famous Schechter poultry case. But for some accident of history, and I think one could guess as to what those accidents were, the cartel idea lived on in agriculture, especially in raisins. Now, the history gets a little complicated, but basically a New Deal era statute authorized the creation of something called the Raisin Administrative Committee. This is not a committee of raisins, but rather powerful people within the raisin industry. 47 raisin industry participants, including those who grow and package raisins. The committee meets in Fresno every year to decide how many raisins should be on the market. Any farmer who has grown more than his quota of raisins has to hand the excess over to the National Raisin Reserve for free. The committee then decides what to do with the reserve. Sometimes it sells them abroad, sometimes it donates them to schools, and sometimes it gives them to cows. I'm not kidding. If it sells any raisins out of the reserve, the committee then first recovers its own operating expenses and then pays farmers any leftover proceeds. Okay. In one recent year, the committee generated $65 million in sales revenue and gave exactly $0 to farmers, spending all of the proceeds on storage fees and the promotion costs. My guess is if you drive up I-5 in the Central Valley of California, you'll pass large warehouses, and they are chock full of raisins. Now, all of this sounds ridiculous, and it is. Why on earth should the federal government be allowed to drive its trucks up to farms and take 30 or 47% of a farmer's raisin crop? But this really isn't the outrage to my mind anyway. The farmers get a pretty big benefit. By reducing supply, the National Raisin Reserve increases price. Farmers get paid more for the raisins that they do get to sell. The only ones who are screwed are you and me. Why should we have to pay more for our raisins? Why should I have to go and sell drugs on the street corners to subsidize my children's raisin habit? Why should Raisin Bran be so expensive? If raisins were cheaper, then maybe there'd be more than 2 scoops in every box. The answer is that there is no answer. Raisin farmers mostly like this cartel as they get paid more for their crop. Otherwise, as Justice Kagan said at oral argument, the law setting up this nonsense is truly, quote, the world's most outdated law, and a New Deal monstrosity as outdated as, say, Italian fascism or Shirley Temple. A California farmer named Marvin Horn had enough. One year, the federal government drove its trucks up to his farm and said, give us your raisins, and he said no. He refused in 2002 to let federal trucks haul away lots of raisins, tons of raisins, that the committee said he could not sell. Horn has continued to refuse to hand over his raisins, and until the Supreme Court intervened, he had racked up fines of $650,000 and owed the federal government 1.2 million pounds of raisins. He challenged this order administratively, and when he was denied, he appealed to the federal courts. Horn argued that these orders requiring him to give away half his crop of raisins to the National Raisin Reserve are unlawful as unconstitutional takings under the Fifth Amendment, and by an 8-to-1 vote, the Supreme Court agreed. Writing for the majority, Chief Justice Roberts made two, I don't know much about takings class, so I'll just say two key contributions. Professor Soman is the expert here and can correct me. Two key contributions. First, the Chief confirmed that the Fifth Amendment draws a bright line between regulatory takings on one hand and physical takings on the other. Let's say a landmark commission denies the owner of a building permission to tear it down and build another more profitable one in its place. Is this a taking? The owner is left with a property. That owner just can't use the property for the purposes that the owner wants. This doctrine falls within a complicated area, a body of takings law, regulatory takings law, that is complicated, it's context sensitive, it's nuanced. Does this apply here? Well, under a case called Loretto, the physical appropriation of property by the government is a per se taking without regard to context sensitive factors about expectations and the like. Loretto, Chief Justice Roberts reasoned, applies to the physical appropriation of not just real property, but personal property. Now, there's some sort of arguable precedential distinction between the two. Justice Scalia wrote a case called, opinion in a case called Lucas that arguably drew a line between the two, but I think the Chief Justice surely has to be right that there's no good explanation for distinguishing between personal property and real property. Second, the Chief Justice confirms that there was indeed a physical appropriation of Horn's property here. Justice Sotomayor, in dissent, argues that Loretto's per se rule only applies when the owner's interest in the property, the destruction of the owner's interest has been total. Here, because the committee sometimes distributed shares of leftover proceeds from sales from the National Raisin Reserve, Horn's loss wasn't total. The Chief Justice redirects this argument. Whatever remainder would go to Horn, he reasoned, would count toward Horn's compensation for the taking, but not deny the taking itself. Now, there's one more interesting issue in the case. The Fifth Amendment doesn't prohibit all takings, just takings without the payment of just compensation. In his partial concurrence, Justice Breyer basically says that Horn can't have his raisin cake and eat it too. Horn isn't really a freedom fighter, he's a cheater. Cartels keep prices up by restricting supply. Horn hasn't played by the cartel's rules for the last dozen years. He's been selling his entire raisin crop, while all other producers have been handing up to half of their raisin crop over to the government. In other words, Horn has been profiting from the cartel's rules even as he cheats on them. To calculate just compensation for takings purposes, one has to deduct from the compensation whatever value the property owner got from the taking. At least that's Justice Breyer's argument in his concurring opinion. Here, Horn got a lot of value from the threatened taking, Breyer suggests, in the form of higher prices for his produce. Perhaps these higher prices cancel out anything Horn lost, and Justice Breyer reasons and implies that Horn maybe has to pay the fine. The Chief Justice says no. When there is a physical taking, the compensation is the taken property's fair market value. The government has assessed that value as the fine it has imposed on Horn. Just compensation requires that the attempted fine be excused. I'm not sure what to make of Horn versus Department of Agriculture, and for this reason I'm particularly interested in Professor Soman's thoughts. Perhaps it rings the death knell for an uncommonly silly law, one that, but for the power of special interests over agricultural policy, would have died a well-deserved death a long time ago. I doubt that Mr. Horn is all that popular among his raisin-producing colleagues. He made an enormous gamble and he won. He sold his excess raisins at the cartel price, and he doesn't have to pay anything for it. Other raisin farmers may do worse after the cartel's demolition, but the rest of us, and this is what I'm happy about, will pay less for our raisins. Okay? But I wonder if Horn sows the seeds of a new revolution in takings jurisprudence. I really have no idea. I wonder how this case will ripen under a sun of future decisions. The distinction between regulatory takings and physical appropriations that the Chief Justice stresses seems awfully aridly formalistic to me. After all, as the Chief Justice concedes, Congress could have accomplished all that our National Raisin Reserve has accomplished had it passed laws telling farmers to let fields lie fallow. These laws would not have entailed physical appropriations in the same way, and thus would have been examined under the more nuanced, complicated, context-sensitive vein of takings jurisprudence. The distinction between the actual law and my hypothetical one involves form over substance. Maybe the Chief Justice knows this, and at some point in the future will make just this argument in a decision orienting takings jurisprudence in a more libertarian direction. Horn provides for robust protection of property rights. I wonder if it's planting the seeds or perhaps the vine of a property rights revolution to come. So Professor Shulman will begin our discussion.
So unlike King versus Burwell case, I don't think this case is a close one, and also full disclosure, I did have some involvement in this case, and I participated in an amicus brief on behalf of myself and a number of other taking scholars on the side that actually prevailed. While this program in some ways is an archaic relic of the New Deal, it is certainly not the only program like it, and there are a number of other farm commodities for which there are similar programs, so there is applicability there. And as I'll discuss in a moment, I think this case also has some important implications for takings law more generally. So I think the most basic reason why this case is correctly decided is just the text of the Fifth Amendment, which says that when the government takes private property, it must pay just compensation. It's pretty obvious that raisins are private property, and when a government sends trucks, rounds up the raisins and takes them away to do what it wants with them, that's pretty obviously a taking of the property under both a lay definition of it and under any technical legal definition that I know of. So I think just the pure text amendment suggests how to resolve this case. Now, the government, however, made two arguments to try to resist this conclusion. They first said, well, maybe the takings clause doesn't protect personal property to the same extent as it protects real property. Real property is property and land, whereas personal property is property and sort of movable objects of other various kinds, including, in this case, raisins, perhaps even dancing raisins would also fall into this category. I think there's no reason to distinguish between real and personal property under the Fifth Amendment. Just looking at the text, the amendment applies to all private property. It doesn't distinguish between different kinds of property. And if you look at the history and original meaning, actually the takings clause was inspired, at least in considerable part, by British unpaid confiscation of personal property during the Revolutionary War and during the colonial era. So if anything, the framers had personal property perhaps even more in mind than real property. And if you do distinguish between real and personal property in this way, you get fairly absurd results. As Justice Alito pointed out at the oral argument, it could mean that if you're a cell phone manufacturer, the government could require you to turn over every fifth cell phone without compensation, because after all, cell phones are personal property, just like raisins are. So the other argument that the government made, which is one that is summarized by Justice Scalia, he said, well, on their theory, the horns are actually ingrates. Because far from being harmed by this program, they actually benefit from it. As was already mentioned, there's this part of the cartel system meant to benefit raisin producers. So the theory is, well, it's not a real taking if the owner of the property actually benefits from it. And I think, again, this argument is seriously flawed almost as much as the previous one. There are many situations where there's a taking, even though the owner might benefit to some extent. If they take part of your land to build a road through it, it's possible that the value of the rest of your land will increase because now more commercial traffic can come into the area, but that doesn't mean your property wasn't taken. Similarly, if they take your property in order to build a military base, you might benefit from the extra national defense that is provided, but again, it doesn't mean your property wasn't taken. And as a practical matter, accepting this argument would mean that the government could take large amounts of property, provide you with some small benefit in exchange, and there wouldn't be a taking. You would get no additional compensation, even if your losses were much greater than your gains. So maybe these gains should count against the compensation you get, but the existence of some gains doesn't prove that you don't deserve compensation. And it's worth noting that if you look at the record of this case, it seems very likely that the horns are not net beneficiaries of this program, that while they could benefit from a higher cartel price, they would benefit even more from being able to sell a larger quantity of raisins, even at a lower price. But in any event, whatever you think of that evidence, it should not count on the question of whether a taking had occurred or not. So one important aspect of this case is that it prevented dangerous precedent from being set, that if the government prevailed either under the personal property argument or under the argument that if you benefit from a property confiscation in some way, you don't get compensated from a taking. Either one of those would have very dangerous implications. It's also significant that in this case, you have 3 of the 4 liberal justices actually voting in favor of property rights. This is actually one of a series of cases where the Obama administration has suffered 8-1 or 9-0 defeats in property cases, including the Arkansas Game and Fish case, the Sackett case, and also actually the first iteration of Horn, which went up to the Supreme Court 2 years ago. Raisins are among the few entities that have been to the Supreme Court not once but twice. This same case was before the court 2 years ago, where the court unanimously ruled that the Horns should be allowed to raise this takings issue and should not be prevented from doing so by Byzantine procedural and administrative requirements the government sought to impose on them. So this, I think, is part of a step forward for property rights in that for many decades, constitutional property rights have essentially gotten second-class treatment at the court, often being denied protection, routinely extended to other rights protected by the Bill of Rights. This case and other recent cases don't fully close that gap, but they take a step in that direction. I think you may be right that in the future the court might adopt a stronger regulatory takings doctrine, though I don't think the distinction between the hypothetical program that you suggest and the actual one is purely formalistic, in that if the government says fields must lie fallow, then what it's doing becomes more visible to voters. Voters might notice, hey, there are these fallow fields, it's not clear why they should be kept empty this way. By contrast, when you have a complex Byzantine structure like this one, most of the voters have no idea what's going on, and therefore it's very easy, or easier at least, for these special interest groups to get away with this sort of a law. So overall, I think this case is a good result. I do think there is a complex issue on compensation that you mentioned that we can talk about later on that issue, unlike the main takings question. I think that one really is complicated, and both sides have some good arguments, and perhaps we'll talk about that more in the discussion. Thank you so much.
I don't really think there's a whole lot that is all that controversial about this case, although I think the history is very interesting. Professor Marcus talked about it. I think it does stand for the principle that the court should never pass on an opportunity to declare New Deal legislation unconstitutional. The first, Schechter Poultry was the first time that the court began striking down the fair competition codes in the Roosevelt administration, but it struck down the Agricultural Adjustment Act of 1933 in 1936. And that is what gave rise, when Roosevelt saw his plans falling, that is what gave rise to his court packing plan. And this act actually was passed as part of a strategic, or at least a book I read last weekend said that this act was part of a strategic initiative by the Roosevelt administration to bring the court packing challenge straight to the court's face. Because in 1937, after the court declared unconstitutional the Agricultural Adjustment Act of 1933, in 1936, Congress repassed the Agricultural Marketing Agreement Act, which is this legislation. And then in 1937 was the famous switch in time that saved 9. You had Justice Stone change his vote. You had Justice Van de Vander resign from the court, and the whole course of New Deal legislation, or the court's review of it, changed. And in fact, the very next year, 1938, the court repassed the Agricultural Adjustment Act on top of this, which had passed in 1937. The reason I remember any of this is because I remember the most outrage I ever felt as a constitutional law student about the extension of the Commerce Clause doctrine, Wickard versus Filburn. And Wickard versus Filburn was decided in 1942, but it dealt with that 1938 version of the Agricultural Adjustment Act, which told a particular farmer, I think he was in Ohio, a guy named Filburn, you can only grow so much wheat on your land, you can't grow more. Mr. Filburn did grow more, but he did not use it except for on his own farm, own internal use. And the court nevertheless found that that had an effect on interstate commerce and upheld the fine on Filburn. I thought that was pretty outrageous. And in fact, when you compare it, as Professor Selman suggests, with the result in this Raisin case, it really is a pretty fine distinction between saying you can grow your raisins, but you have to give them up, or you can just simply only grow so many raisins. But I do think that the difference, while fine, is a discernible difference. There is some discernible difference between taking the raisins and just saying you can only grow so many raisins. And so I suppose that even though Wickard remains good law, although that has been questioned by some, it is reconcilable with Horn. The one point, since this is Constitution Day, and since I am more simple than the rest of the panel, that I think ought to be made here is, this was an unconstitutional law that was on the books for 80 years, and it operated for 80 years. It does represent, I think, a significant limitation on the court's power. Courts are not free-roving constitutional conventions that take a look at legislation and decide that they're unconstitutional unless they're asked to do so. And as a result, this law remained on the books for 80 years, even though the court now says on an 8-1 vote it was unconstitutional, and presumably it has been so for 80 years. If you go back into the very founding days of the Republic, as you may recall, when Marbury versus Madison was decided, Jefferson was outraged because he thought that every branch ought to be able to decide the constitutionality of legislation for itself, and the court should not be able to appropriate this special role of declaring things constitutional or not. And I think this case does demonstrate, at least in part, that Jefferson was right. And that is, in my time as a judge, I have encountered several state laws and at least one federal law that I believe are unconstitutional. But I encountered them in settings where no one was challenging them, and so I had no occasion to declare that they were unconstitutional. And as far as I know, they all remain on the books. I do sense a disturbing trend in politicians and legislators and others to suggest, for whatever popular value it is, and for political gain, the advocacy of measures that are clearly, in my view, on their face unconstitutional. And I have heard one say in the newspaper last year that, well, if it's unconstitutional, that's fine, the court will tell us so. Well, if legislators want to take that attitude, then they are empowering me far more than they should. They should take the attitude that Jefferson suggests, that they have some responsibility for also determining and passing, or determining whether legislation is constitutional before they pass it. And when they don't make that determination, the only result I can conclude is we still have legislation on the books that is not constitutional, and that will remain on the books and govern our lives unless and until someone challenges it. I don't know that that's a bad thing to the extent that it is a limitation on the court, and the court should certainly not be a free-ranging constitutional body of adjudication. But I do think that that invites legislators and executive branch people to be more vigilant and to take the responsibility to consider the constitutionality of what they're doing.
Okay, I will confess that I also had no idea that there was a massive national raisin cartel until this case appeared on the Supreme Court docket. I think the program is pretty plainly a New Deal holdover whose Depression-era justifications, if they ever existed, have surely passed. And I think the fact that 8 of 9 justices got there in this case speaks volumes. I agree that it's absolutely noteworthy that no justice would have treated the program differently because it dealt with personal instead of real property. So taking raisins that these people owned instead of acreage that these people owned. And that's because even Justice Sotomayor wasn't arguing that this is a relevant distinction. She was just focused on whether it was a per se taking when the taking wasn't, in her view, total, because they might have had some rights to those residual payments that might accrue to them. On the ground, in the agricultural world, my understanding is that the impact of the holding is close to zero. Today, grapes are used more for wine and juice. No raisins at all have been set aside for reserves in the last couple of years. I read an article that suggested that only a couple of agricultural products, so maybe tart cherries and spearmint oil, remain under similar systems. So this isn't bringing about some sweeping set of real-world consequences in that sense, I think. But it does make us think going forward about all the ways that we could perhaps have some parallel to this agricultural regulatory system. The government could maybe have what is at base a regulatory program, but the means used to carry it out involves a clear physical taking of somebody's property, and so that's going to be a physical taking, not a regulatory taking. This might be true, for example, of government agencies taking your pet if you mistreat it, or the FDA seizing adulterated drugs, or the law saying you no longer get your firearm if you're a felon, or the government seizing the property of criminal wrongdoers, even if that property isn't connected to the crime. And that might create a tangle that the court is going to have to work through. Now, I can think of ways that maybe these situations are different than raise and reserves, but I still think that we're going to have to work out the details of how they're different. I also want to raise the question of that Ilya raised that we didn't really talk about whether we really mean it when we say that we need to disaggregate the initial question of whether there was a taking at all from the second question of what was just compensation for that taking. And I agree that the government was wrong in trying to argue in this case that if the owners of these raisins benefited from the government program, then suddenly there was no taking. And almost the full court agrees that this is nonsense, right? If the property was taken, it was taken. And were the court to have held otherwise, as Ilya points out, the government could avoid paying compensation in a whole bunch of other cases where property is taken by the state for purposes that might happen to benefit the owners in some way. And the example that was given in the brief that Ilya joined was really helpful to me, right? It's this example of the coastal property where they put in they take a piece of the coastal property to put in the military base, and the owner derives some benefit from its construction because suddenly it's a very, very safe piece of coast. And that does not, as was argued, mean that no taking has occurred, but rather there is a taking, and this guy who owns the coastal property is entitled to full market value compensation. And the calculation of that full market value compensation becomes much more complicated and sophisticated because there were some gains and there were some losses from the government's action, which was for sure a taking. Now, given this, I can't understand why we wouldn't necessarily think that Justice Breyer's opinion in this case was right, that we have to remand the case for a determination of whether the program, after all the math is said and done, helped or hurt the Horns, and by how much. The Horns situation, I think, is in fact like this partial win, partial loss situation in the coastal property military base example. They lose the fair market value of the raisins, an amount that has already been calculated in the government fine. But if the raisins had actually been taken from them, they would also receive the benefit of an inflated price for the leftover raisins and full compensation at the same inflated price for the reserved raisins. And all of this is at the expense of the raisin buying tax-paying public, which is setting Dave off. And Justice Breyer, in his opinion, seems to be saying, look, we can't say for sure whether there's a windfall for the Horns in this situation. And maybe there isn't, right? But we at least, because we've argued so vehemently that you have to disaggregate the two questions, we at least ought to follow the second question through to its completion and do the math. And I think if we're actually committed to disaggregating the takings question from the just compensation question, we should at least take a shot at doing that calculus instead of just declaring that there was a taking for which the compensation was not just. It seems to me that those who are arguing strongly for that disaggregation as an initial matter ought to support that remand as a subsequent matter.
Okay, we are supposed to stop right now, but if I may, we have 10 minutes. Oh, great. I just want to first say that I'm pleasantly surprised to learn that my raisin prices haven't been all that inflated the last couple of years. That really did set me off.
They weren't better in previous years, however.
In your childhood, they were grossly
Before I became such an income generator as I am now, I was paying so much for raisins. I don't know if any of the panelists wants to respond to what you said before we invite a question.
An extremely brief statement about Wickard versus Filburn. I too was outraged by that when I was in law school, and I still am. But that case raises different issues from this one. Is that case raised the issue of whether this was within Congress's powers under the Commerce Clause, and the Supreme Court said yes, it was. Congress can do this. I think they said it wrongly, but something that is within Congress's enumerated powers can nonetheless violate individuals' rights by violating the Fifth Amendment. So I don't think there's any clash between the result in this case and the result in Wickard versus Filburn. In another setting, I would argue why Wickard versus Filburn is wrong, but you can believe that Wickard versus Filburn is completely correct and is a wonderful precedent, and yet also believe that Horn is correct.
You can certainly do that, except if you try to explain the difference to a layperson, you'll have a hard time.
I've explained this to lay people many times, and they get it when they understand there was being a structural constraint on congressional power and an individual right.
Just to say one final thing, Judge Snow, I'm comfortable with the idea that any challenge to a first-generation New Deal program is a good challenge, but not to the second iteration of the New Deal, which is the Social Security iteration and so forth. The first few years were silly, and then Roosevelt got it all right after that. So, okay.
At least we can hope that we wait 80 years.
No, they had a few mistakes, and some of them have been preserved due to public choice problems, but fortunately the second New Deal survives. Okay, questions. We have a few minutes for questions. John?
So you talked about the two questions of A, whether there's a taking, and B, what just compensation for that taking should be if there is one. But I wonder about the third question, which is whether it's a valid taking, whether there's a public use behind it. And I know Justice Thomas concurred and said that there wasn't. But I was kind of surprised that no one else signed on to that. And I wondered if you could talk about whether it matters that the law was passed as part of the New Deal when there might arguably be a public use. But it continues up till today when it doesn't seem to be benefiting anybody except the raisin growers.
So I'm glad you brought up that question, as I've written an entire book about public use that just came out, focused on the Kelo case. And I think there's a couple aspects to your question. One is, why didn't anybody but Thomas raise this issue? The other is, was there in fact a public use here, and how we should address this? On the issue of why it wasn't raised by the others, I think it's because it wasn't raised in this litigation. It wasn't raised by the parties to the case. And Thomas himself sort of implicitly acknowledges this. On the issue of whether it is for a public use or not, I think it clearly is for a public use under current precedent like Berman versus Parker, and most recently Kelo versus City of New London, the case my book is about. There, the court has said that a public use can be pretty much anything that the government says it is that might benefit the public in some way. And as you very correctly explained, this program hurts the public rather than benefits it, but the standard is something like, could some person imagine in some conceivable way that the public might be benefited? And you could believe, if not for this wonderful set-aside program, raisin producers would go out of business and there wouldn't be any raisins available anymore, and things would be terrible, and the Great Depression would return. That was the kind of thinking that under raisins in the 1930s, yes, grapes of wrath would emerge. And so that would be enough to pass the test under Kelo. In my writings, and obviously I'm not the only one, I've argued that we should instead adopt a narrower view of public use, which is more consistent with the original meaning and history of the clause, which says that a public use must be the taking of property either for a government-owned project like a road or a bridge or like, or for a public utility or the like that has an obligation to serve the entire public, such as a, for instance, a waterworks or an electric company and the like. Under that approach, there might not be a public use here, though it's complicated because some of the raisins are essentially end up being transferred to private parties or sold in a market, but other ones might be retained for government's own use. So if you applied a narrower definition of public use to this, it would actually be complicated whether it's for a public use or not. And Thomas carefully, I think to some extent he recognized it. He says, I think it probably isn't for a public use, but citing his very good dissenting opinion in Kelo, but he said, well, it's not completely clear. So if we were going to go into this analysis, it would be a Dibble analysis, but fortunately in this case, we probably wouldn't have had to, because if their ruling had been this is a taking that's not for a public use, then the entire thing is invalid. Normally when something is ruled to be a taking not for a public use, the government has to return the taken property, but in this case, as I understand it, the raisins were actually taken away and I assume consumed somewhere or destroyed. So really the only realistic remedy that could be had is compensation for a market value of the raisins, or compensation for a market value minus perhaps whatever benefit. There might be a question there. But I do think in the future, I hope the court will revisit the issue definition. You might look about the Kilo case. I explained why that might, that could well happen.
I'll toss in that Thomas also pointed out that in his view, the remand to do the mathematical equation about whether the compensation was just would be fruitless.
If we're doing a
One
race
of
on a
many
public
Lots of little puns.
puns that were woven throughout the opinions in this.
Yes, he does say that, though. I actually think the remand might not be completely fruitless or mindless or whatnot, because it would actually be somewhat complicated to try to figure out what is a remedy for a public use violation in a case where you can't actually return the property in question because that property is in someone's stomach.
And the fact that this involved a fine for refusing to hand over the reserve raisins instead of the actual taking of all of the reserve raisins further complicates it, I think.
Yeah, I think.
As I understand it, the Horns actually did lose at least some of their raisins. And
I think year one they lost their raisins, year two they
Yeah.
stood firm and
Yeah, so there might have been some complex calculations.
they were the Clive Bundys of
They
raisin
could
world.
have been done on remand, or Justice Thomas could have written a more detailed opinion on how this should be done, but there would have been some difficult issue to address there. Okay.
I think the Chief Justice doesn't want to remand for a fairly simple reason, which is really because most of the raisins were not actually taken, and that the Horns they just refused to relinquish their crop. That in a sense, the remand the mathematical calculation might have been you have to pay some of this fine because you've been benefiting from the cartel price, but that's so offensive that the government could nonetheless fine the Horns for violating a law that's unconstitutional. That'd be my best guess. One final question before we take a break. Dean Robertson.
I want to follow up on Professor Marcus's fleeting notion of the formalism of this case. If there had been a magic word like contraband and turned it into the statute, saying it's contraband to produce more than you're allowed, would that have flipped the whole outcome of the case? And if it's not about that magic word, should we worry about the FDA's power to seize misbranded drugs, or the Customs and Border Patrol power to seize pirated DVDs, or blah, 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 blah. I mean, I give 100 examples where we have seizures.
We take personal property all the time as a government.
So is there just a magic word that's missing in the statute?
So it's a good question. I think the answer is sort of twofold. One is there are some fuzzy lines here, but usually there's a line drawn between property which by its very nature is illegal, for example, owning drugs which are just categorically illegal, versus property where it's not of a type that's generally illegal, but we're seizing it in this particular case as part of some regulatory program or the like. So it's not as firm a distinction as it should be, and I would push the distinction out and deal with some of these cases like asset forfeitures, the Supreme Court has said are not takings, but I disagree. I think in many cases they are, particularly where the person hasn't even been accused of any crime, as is often the case. For the moment, the distinction is sort of more of an I know it when I see it kind of thing. Like it seems to be raisins by their nature are pretty obviously not contraband, whereas some of the examples that you've given probably are. I would prefer a stronger bright line rule, but I don't think even under the status quo it's simply a situation where the government can put the word contraband in it, then it's okay. The government could create a regime saying, well, raisins are like marijuana, we don't want anybody to have them, and so we have a Controlled Raisins Act, like the Controlled Substances Act, then maybe there wouldn't be a takings issue. But if they're saying raisins are generally legal, but we're confiscating some to prevent too many from being produced or whatever, that's pretty clearly a taking and not merely contraband or whatnot.
We're already there in states that medical marijuana, because they're regulated by quotas. You can have so many plants, for example.
Yeah, that could be, and maybe some of those will raise some takings issues, though it's complicated because obviously all that is still illegal under federal law.
The Chief Justice does allude to this issue, discussing a case where the court upheld a law that requires producers of, I think, toxic insecticides or something like that to hand over their trade secrets in exchange for being authorized to sell these products. And that's a soft spot in the Chief Justice's opinion. He simply says
This is a healthy snack.
Yeah, he says that raisins are a healthy or a tasty snack, while these are dangerous products. But there is no, I don't see a conceptual distinction that holds up all that well. We do have to
There is a
stop.
conceptual distinction.
But you can discuss that during our break, because we do have to stop. We will take a break.
Yes, 10, 15 minutes.
let's say 10 minutes because I was so late, so I'm going to impose that on all of you. I will take a 10-minute break and reconvene about 2:45 to begin the discussion on this case.
We'll take more of your time with that.
Yeah, exactly. Yeah. Okay, so our third case is probably the most high-profile case of this past term, Obergefell. There's some. I'm not entirely sure how to pronounce this word. I pronounce it Obergefell because it reminds me of my grandmother. It sounds like a Yiddish word, like, oi, that Obergefell is a real Meshuggah. But I don't know if that's right. So I'll just call it, say Obergefell and think of my grandmother. Obergefell. Still sounds Yiddish. Okay. Obergefell. Got it. So I'm going to take a few more minutes, the liberty of taking a few more minutes for my case presentation here, because none of us on the panel is specially designated as the lead expert. So if you all will indulge me. On May 18th, 1970, Jack Baker and James McConnell applied for a marriage license in Minneapolis. When they were denied, they sued. Baker and McConnell argued that the right to marry a spouse of one's choosing is a fundamental right protected by the Due Process Clause of the 14th Amendment, and that Minnesota's denial of this right to same-sex couples violates the Equal Protection Clause. This, what we call it, sort of a double helix of constitutional argument. Ruling against them, the Minnesota Supreme Court's analysis can be summed up in one sentence. The incident, here's quoting the decision, the institution of marriage as a union of man and woman uniquely involving the procreation and rearing of children within a family is as old as the book of Genesis. The U.S. Supreme Court dismissed the appeal that McConnell and Baker brought for want of a substantial federal issue. That's a way of the court saying, you got to be kidding me. Baker and McConnell did get the last laugh. One of them changed their names to a gender-neutral name. They went and got a marriage license from a neighboring county and pulled a fast one in the state of Minneapolis. In 1971, they were married in a lovely ceremony, both wearing identical white bell-bottomed pantsuits. Little change over the next 35 years. In 1991, a poll revealed that 75% of Americans believe that homosexual sex is immoral, while only 10% of Americans supported same-sex marriage. When a court in Hawaii ultimately ruled in 1996, after years of litigation, that same-sex couples had a right to marry, the people of Hawaii swiftly responded, amending their state constitution by an overwhelming vote to prohibit same-sex marriage. Congress also got into the act after the Hawaii episode and passed the Defense of Marriage Act, a statute that denied federal recognition to any state-sanctioned same-sex marriage on grounds, to quote the House Committee report, that heterosexuality better comports with traditional, especially Judeo-Christian morality. The Defense of Marriage Act had the support of 68% of Americans. By 2001, 35 states had enacted statutes or constitutional provisions to, quote, protect traditional marriage. When the Massachusetts Supreme Judicial Court ruled in favor of a same-sex couple in 2003, a series of referenda followed in 13 states, each of which passed, and the idea that each was to preserve the traditional definition of marriage. The referendum in Ohio passed by 24%, bringing enough conservative voters to push into the polls to push the state into George Bush's column. It's fair to say, I think, that the 2004 election was decided by a backlash to the notion of same-sex marriage. So this is the United States circa 2004. 11 years later, the Supreme Court determines in Obergefell that the 14th Amendment vests a right in same-sex couples to marry. How does this happen? Well, there are many paths one can chart from the United States circa 2004 to this past June's decision. It's well beyond my capacity to discuss the social and cultural history, so let me just focus on the doctrinal path that the court followed. Obergefell represents a culmination of the court's evolving jurisprudence of individual rights. The 14th Amendment offers two bases for a right to marry, as McConnell and Baker surmised: equal protection and substantive due process. As of the late 1990s, neither offered same-sex couples much hope. Traditional equal protection analysis pegs the level of scrutiny that a court will afford some statute to the type of group that the plaintiff belongs to. Only those laws disadvantaging suspect classifications like race or nationality are subject to searching strict scrutiny. Well, the court last recognized a group that benefits from this special solicitude in 1977. It's highly unlikely the court was going to recognize LGBT groups as deserving of strict scrutiny. In Washington versus Glucksberg, a 1997 decision, the court held that substantive due process protects those fundamental rights and liberties which are objectively deeply rooted in this nation's history and tradition. The argument that same-sex marriage is deeply rooted in this nation's history and tradition is a pretty hard one to make. But since the mid to late 1990s, the court has moved steadily away from these doctrines toward a merged equal protection substantive due process hybrid, this double helix, that insists upon equal respect for everyone's individual dignity. In Romer versus Evans in 1996, the court invalidated a malicious Colorado statute that singled out gay and lesbian people. It invalidated this law under the Equal Protection Clause without specifying what level of scrutiny it was examining the statute with. In Lawrence versus Texas in 2003, the court invalidated Texas's law against same-sex sodomy. Justice Kennedy, writing for the majority, eschewed traditional equal protection analysis and opted instead for this substantive due process equal protection hybrid. The Constitution protects a fundamental right to intimate association, a liberty interest that the state cannot invade based on moral disapprobation. Once that case is decided, as the dissent in Lawrence versus Texas suggests, the road to same-sex marriage becomes a lot clearer or easier to follow. In the United States versus Windsor in 2013, the court continued with this theme. Windsor is an odd mishmash of substantive due process, equal protection, and federalism, but there's a key line in the opinion that makes the turn in the doctrine clear. Same-sex marriage, quote, is a far-reaching legal acknowledgement of the intimate relationship between two people, a relationship deemed by the state worthy of dignity in the community, equal with all other marriages. So here are the seeds planted in Romer, watered in Lawrence, and just about to flower in Obergefell. Marriage is the legal recognition of an individual's dignity, a liberty interest that one individual should enjoy equally with all others. This brings us to Obergefell itself, where Baker and McConnell's constitutional arguments finally prevail. Now, there are many striking things about the decision. I urge those of you who are thinking about a career in impact litigation to look at the plaintiffs that brought this case. They are unbelievably good plaintiffs. There are neonatal nurses who have adopted special needs children and want to have the state of Kentucky, or I think it was Kentucky, to bless their marriage. They include an Army sergeant just back from an Afghanistan deployment. Okay, that's one striking thing. There's another Justice Scalia temper tantrum. That's a good one to read. Really striking is the tin ear that the Chief Justice has for history. The Chief Justice in his dissent actually compares this case to Dred Scott. Whatever you think about the merits of the case, surely the suggestion that this case is somehow as evil of a moment as Dred Scott is an astonishing thing to contemplate. I'm quite confident history will judge the Chief Justice harshly for this error. But what is really striking is how seemingly formless the court's approach to substantive due process and equal protection are. Justice Kennedy, writing for himself and the four liberals, abandons Washington versus Glucksberg entirely. He begins his discussion with the insistence that the substantive due process task requires courts to, quote, exercise reasoned judgment in identifying interests of the person so fundamental that the state must accord them its respect. History and tradition guide and discipline this inquiry, he continues, but they do not set its outer boundaries. Well, this is astonishing. Substantive due process is the Lochner rail of American constitutional law. Judges do everything they can to avoid touching it. Justice Kennedy's articulation, which is so capacious as to seemingly admit of no obvious limit, all but thumbs its nose at the Lochner anxiety. Kennedy bases his determination that the right of everyone to marry is a fundamental right based on four principles. First, the right to personal choice regarding marriage is inherent in the concept of individual autonomy. Second, the right to marry is fundamental because it supports a two-person union unlike any other in its importance to the committed individuals. I want to stress, these principles are so evocative of the idea of individual freedom. An emphasis on individualizing the right and individualizing the freedom here. Third, marriage safeguards children and families and thus draws meaning from related rights of child rearing, procreation, and education, things that happen in the individualized private sphere. And then fourth, marriage is the keystone to our social order. This right is so fundamental that to deny it is to visit a significant dignitary harm on those who do not enjoy the right. This is where Justice Kennedy's equal protection analysis kicks in. But it isn't the ordinary or the old-fashioned tiers of scrutiny analysis. rather by defining the liberty interest in the way he does, rooted in personal choice, a two-person union, the protection of children in the private sphere, Justice Kennedy makes the equal protection result obvious. There is no difference between same-sex couples and opposite-sex couples with respect to these principles. Kennedy observes, and there's no conceivable basis to deny the former the same dignitary recognition as the latter. That's it, basically, for Justice Kennedy's analysis. Many have derided his opinion as short on analysis, short on legal rigor, and long on windy speechifying. I strongly disagree. Obergefell is a profoundly important decision for its doctrinal moves, for its explicit recognition of what Kennedy calls the interlocking nature of due process and equal protection. The decision sets the doctrinal agenda for constitutional lawmaking going forward. Does Justice Kennedy resolve every nuance for how to use this new interlocking helix? Of course not. But it does set an agenda going forward in an explicit way. Also, Kennedy's distillation of the four principles is a tour de force of doctrinal engineering. Kennedy identifies each of these principles in the most important decisions about privacy, individual dignity, and autonomy from the 20th and 21st centuries. The opinion may lack a useful articulation of rules or standards for future decision-making, but its assembly of precedent into a coherent whole is a masterpiece. Okay, just a couple more minutes if you'll bear with me. If you, like me, celebrate the decision as long overdue, is there any reason to rain on this parade? I don't think so, but there might be a little tiny bit of drizzle for people who consider themselves lefty, hippie types like myself. Is there any price to be paid on the left for a decision like this? There might be a small one. The decision is the end of a lengthy doctrinal revolution that is all but laid to rest, an old vision of the Equal Protection Clause. This old tiers of scrutiny analysis required the court to describe groups, to identify groups, to recognize the existence of groups in the American social fabric, and to make some claim about the either advantage or disadvantage that that group does or doesn't enjoy. The court doesn't like this. The court doesn't want to recognize certain groups as unusually deserving of its concern and thereby entrenching balkanized group identities into the American social fabric. This old equal protection doctrine may not have been well designed to eradicate discrimination based on sexual orientation. The court never would have identified LGBT people as a group that merits its particular solicitude. By dodging the tiers of scrutiny issue, the Romer court signaled the end of this old equal protection. Lawrence, Windsor, and this decision put the nails in its coffin. Instead of a group-based equal protection doctrine, we now have an individualistic one. Let's determine whether something fundamental is denied to individuals, whoever they are, and whatever their identity is. If so, the Equal Protection Clause kicks in. You can't just recognize a fundamental right for certain individuals and then deny it from others. There's no need to figure out what the group is, to whom it belongs, and how much protection it merits. We're all the same, with equal dignity, and the state cannot say otherwise. This new equal protection is well suited for eradicating discrimination against same-sex people, members of LGBT groups, same-sex couples, and the like. The idea is simply to require that the LGBT people get treated the same as everybody else. There's no special solicitation needed. But this new equal protection is not well suited for what one might call an anti-subordination approach to equal protection. An alternative view of equal protection, one not particularly well served by the old tiers of scrutiny analysis, but one that has nothing to do with this new individualistic emphasis, is the idea that equal protection is about eradicating castes in American society. Certain groups are systematically oppressed, by legal forces to be sure, but also social ones. This anti-subordination approach to equal protection permits laws that can shield these castes, these systemically oppressed groups, from the full brunt of their oppression. These laws, the Equal Protection Clause permits laws like that invalidated in the Parents Involved case, an effort by the Seattle Public School District to integrate its schools with modest racial preferences for non-white students. This old equal protection doctrine required the court to recognize the existence of groups in American society, to appreciate how American society orders these groups. This picking of winners and losers is something the court hates to do. Justice Kennedy's new individualistic treatment of equal protection, one that denies that groups are relevant to American constitutional law, must have proven attractive for just this reason. This decision proves that the arc of the moral universe is indeed long, but it bends toward justice. I just wanted to raise the possibility that there might be some systemic inequality left behind as that arc does in fact bend. Okay.
Okay,
Okay, so I wanted to focus my comments in a really personal way in this case because I attended oral arguments in Everettville. I was in town and was fortunate to sit in the courtroom as a guest of Justice O'Connor for my clerk. And I find this case to be a really, truly interesting case on the role of oral arguments and our practice of reading the tea leaves within them. And so I wanted to chime in on that front about what we saw from oral argument in what is really, I think, the major case of our generation. It ticked every possible box on things that people like to talk about oral arguments. Firstly, when I arrived, there were people lined up all the way around the block and had been there camping out overnight, some of them for more than one day. Most of them were poor or homeless people who were being paid by law firms and wealthy individuals to sleep outside in the rain to hold the spot for them in anticipation, and then the wealthy people showed up in their suits 10 minutes before the doors opened. And this reignited the debate about public participation in oral argument and the arguments that I and others have made about the possible need for cameras in the courtroom so that all Americans can have access to arguments in real time in some of these major cases. Next to stories about crowds gathering for oral argument, our favorite stories are arguments about protesters at oral argument, and we got that in this case as well. Midway through the arguments themselves, we had a very loud protester. Truly, my ears were ringing from this protest for well into the afternoon. It was just screaming at top volume, shouting homosexuality is an abomination, and this is an abomination before God. He was quickly taken outside by security, but his shouting was heard echoing through. The building is made of marble, and so it echoed through, and you could hear him as he was being taken by security, and then you could hear him, they had taken him outside, you could hear him outside the window still screaming really loudly, and it was, Justice Scalia called it refreshing. I'm not sure that I found it refreshing, but it was disruptive, and it was interesting, and it was the sort of thing that I think the American public would have liked to have seen in real time. On the substance of the argument itself, people really love to tear apart oral arguments at the Supreme Court in important cases and try to predict votes and outcomes before the cases get decided. And this case was really a doozy on that front. The attorney for the gay marriage plaintiffs, Mary Renato, who is a revered LGBT activist, started arguments by calling marriage, quote, the foundation of family life in our society, and suggesting that relegating gay couples to second-class status conferred a stain of unworthiness upon them. But before she could get very far down this line of thinking, Chief Justice Roberts, in a question that began exactly 2 minutes into things, immediately removed any hope that some had held out that he, out of concern for his legacy as chief, might join a 6-3 opinion in her favor. He asked a question that was not so much a question as an assertion. He said, "You're not seeking to join this institution, but to change what the institution is." And you could feel the statement in that room, right? Roberts wasn't voting with the liberals. This question had sort of instantly, straight out the gate, sent that signal. And then every eye is on Justice Kennedy, who would clearly be the swing. At 10:06, he jumps in with a similar question about the longstanding view of marriage as being between two members of the opposite sex. The word that keeps coming back to me, he said, this is the first words out of his mouth in oral argument, is millennia. Same-sex marriage had been legal in the United States for only about a decade, since Massachusetts legalized it in 2006, Kennedy says, and he insinuates that that's a tiny, tiny amount of time compared to the vastly longer period that it's been defined as between opposite sex. I don't even know how to count those decimals, he said. This definition has been with us for millennia. And again, there are gasps in the courtroom, right? Nervous shifting on seats. Kennedy is seeming straight out the gate to also be skeptical. Then we get some predictable lines of inquiry. Justice Ginsburg pointing out that historic definitions of marriage made women into chattel and surely are not to be clung to. Justice Alito asking whether this wouldn't open the door to recognition of polygamous marriages. Justice Scalia expressing reluctance to establish a new right that he thought would be so, quote, unpalatable to people of faith, and asking whether this constitutional right would force clergy to perform same-sex weddings. And then during the SG's time at the podium, an inquiry about what this would mean for religiously affiliated universities. The most engaging exchange in oral argument that I've ever seen happen at the Supreme Court occurred when the lawyer for the state of Michigan got up and launched this truly fantastic back and forth between and among the justices on the question of whether the ability to procreate is somehow central to marriage. Conservative justices argued yes, saying things like the preservation of the childbearing traditional family unit was the clear motivating force behind the institution. Liberal justices shot back with this really fun string of hypotheticals that just came sort of one after another from the bench. What about straight people who are married but are 80 years old? You know, is their marriage illegitimate? They can't procreate. What about straight people who struggle with fertility or choose not to have children? Do we invalidate those marriages? Kennedy, again, sending a seemingly opposite wild hint about his position, said this: isn't it the case that children and families are strengthened by gay marriage because kids could be adopted into loving LGBT families and could have greater legal ties within those families? The true kicker at oral argument came when the argument turned to the second question presented, which you might remember was, may a state that chooses to ban same-sex marriage be forced to recognize a same-sex marriage that was performed in another state where it was legal, right? This full faith and credit question. And suddenly, Kennedy is silent. He's leaning back in his chair. He's looking around unattentively. And if you were carefully thinking about it, as loads of us were, you think maybe he isn't focused on this question because question 2 only gets answered if question 1 about the overall state of affairs and the constitutional right to gay marriage isn't answered in the negative. If there's a nationwide constitutional right to do this, we're not going to have the full faith and credit question come up because there won't be states with differing standards. Everybody's going to be required to have it. He's disengaged on question 2 because he's answering question 1 in the affirmative and he's finding that right. And that's, in the end, exactly what he did. And loads of people sort of predicted this, not really from his line of questioning, but rather from his absence of questioning on the second question. All told, I think oral argument in this case, like the case itself, was really one for the ages. And I think, as I said, it really drove home how very valuable it could be for us to make it possible for more than just the 200 or so people who are connected to the justices or have enough money to pay someone to stand in line for them overnight, to be able to watch the court in action as it wrestles with these really hard issues in these really watershed cases. And I think oral argument at the court is something we talk about too little, and maybe ought to think about talking about some more. Obergefell, I'm hoping, will launch that dialogue.
I'm going to appreciate appearing on this panel just because of some of the things that Professor Marcus said that raised new thoughts for me. But I think as I sit here, I disagree with him. So I'm going to challenge him a bit on them. And it doesn't have anything to do with the underlying result of Obergefell, but I do think that the nature of the majority decision itself is so formless as to be of very little value to lower courts that apply. And I'm going to give you some reasons why, and then I'll invite you, of course, I'm sure you will, to respond. I have the great privilege, and it is a great privilege, to teach every summer with Justice Bales, who's in the room, Chief Justice Bales, high school government teachers about the last Supreme Court term. We teach historical Supreme Court cases. We don't always agree, and by the way, he did remind me today during break that I misnamed the justice who was a switch in time to save 9, as he often does correct me. It was Justice Roberts. But we had to teach the class this year, and we thought that Obergefell would be decided before we taught, but it wasn't. It was decided 2 days later. And I did the presentation on Obergefell, sort of anticipating it, and I said to the teachers that while I had a personal belief about how the case would come out, a personal prediction, which was how it did, that I thought the rationale that the court would use in deciding Obergefell would be every bit as important as the nature of the decision itself. And although I didn't say this to the teachers, my own prediction and thought would be that Obergefell would provide a rooting in more traditional, one or the other, substantive due process or equal protection than I had seen in Windsor. The case came out, and then that next week, I happened to be in San Diego at the Ninth Circuit Judicial Conference, and Justice Kennedy is the Ninth Circuit Justice, and as a Ninth Circuit Justice, he does come to the Ninth Circuit Conference, and he addresses all the judges. And he did address Obergefell, and what were his first, or at least the newspaper covering it that day said were his first public comments on Obergefell. It was interesting that he, because he was widely viewed, and I think correctly so, as being the single person to decide whether or not this right existed, he said that for him, he never believes that it's 9 Supreme Court justices that decide what the constitutional rights of the United States are.
that he believes that it is a dialogue that belongs to all of society and to all of us, that we all need to be involved in that dialogue. And then he offered some fairly, I think, eloquent and even moving examples of why that should be so. I had not yet read Obergefell, although I had read some criticisms of it. And earlier, the Ninth Circuit judges themselves had offered their analysis of Obergefell while he was in the audience, and so to some extent, I think he was addressing that. And then I went and read Obergefell, and it seems to me that it did kind of embody the vision that he was trying to share in that talk with the judges about belonging in a society in which everybody participates and everybody wrestles it out. And I believe that that was very much his purpose. That being said, Professor Marcus, you said the court doesn't like to pick between winners and losers, but that is exactly what the court is called upon to do. I am going to be called upon in the future, I think, to pick between winners and losers on this very question. Let me offer a few examples. We live in a state that has some significant pockets of polygamous population. Our clerk's office expects and has been told that some members of those populations are preparing complaints right now, based on Obergefell, to have polygamous marriages recognized. I do know that in his decision, Justice Kennedy uses the word couple. But you'll recall in dissent, Chief Justice Roberts points out that he never says it's two. And I'm not really sure it means it's two. My wife is a quilter, and they're the best quilting group in one of the best quilting shops in the Phoenix area is run by 3 gay guys, and they are terrific in quilting. And so one of my wife's quilting friends runs in the house after Obergefell, and she says to me, "So can the 3 dudes get married?" And I had to say, I can't answer her question. Because I think in that part of his decision, which was substantive due process, where you talk about, and he does talk about personal autonomy and dignity, and I think he does so in very moving ways. How do you draw that distinction between a polygamous or a 3-person marriage if that provides personal autonomy and dignity to the individual? I think it's easy, perhaps, to view Obergefell as a decision that says nothing more than that a marriage between 2 individuals, regardless of their orientation or race, is a substantive due process right. But the truth is, in the opinion, he opens lots more doors than that, and I think he intended to. And he opens a lot of doors, as you said, on the equal protection side of the analysis, and it may be, I never heard before the idea that this is sort of an interlocking right. But even if it is, it's going to require in its application winners and losers. And I think we're going to have to figure out who they are. Some of the more interesting equal protection, or at least maybe traditional equal protection analysis of this, come up in the Kim Davis sort of situations where you have a clerk who refused to issue marriage licenses. I think clearly she's in contempt of court. People have to have licenses to get marriages. The United States Supreme Court has said people are entitled to get marriages regardless of what you think about their sexual orientation, and I think it's right that she be held in contempt of court. But there are more nuanced questions that are surfacing, and one of them has taken place in Arizona itself, and now appears to be subject to be challenged. Judges, for example, are authorized to perform marriages, but they're not required to. It's a discretionary function. Shortly after Obergefell came out, the Arizona advisory opinion was issued to all Arizona an advisory opinion was issued to all Arizona judges that said that they were required to perform marriages for anybody who asked them to do it, whether it was same-sex or whether it was opposite-sex marriages. But then, in what I think was a much more nuanced consideration of the question, an revision to that advisory opinion came out and said, judges are not required to perform marriages. So if a judge does not want to perform any marriages, they don't have to. But if a judge performs a marriage, then the judge must be willing to perform any marriages without discrimination. And that strikes me to be perhaps a more wise and nuanced analysis of the question, which takes into account perhaps a judge's desire to perform no marriages at all, or a judge's religious-based objections to performing same-sex marriages if he or she had objections to doing so. Some states have not had that. Well, I will say that there are various groups in Arizona that have made it clear that they intend to challenge that question in the federal courts. I comment on it because I, for other reasons, would be required to recuse in any event and won't decide that particular question. But I do believe that there are many such questions that are out there that will have to be decided. And in his very embracive approach, Justice Kennedy not only says that, and I think correctly so, seems to imply that some things about a former strict scrutiny analysis might apply, or some of the prerequisites to strict scrutiny analysis might apply to the gay or LGBT community. But then by the same token, he says there's nothing about this decision that will prevent religious people from practicing and teaching their religious views. And that seems to put this decision kind of on a collision course with the approach adopted by the Supreme Court in the Hobby Lobby case. And Judge Soman, I'm aware that Hobby Lobby is a statutory interpretation case and not a constitutional case. But it does suggest some of those same principles. And as I think about some of these cases that I think the federal courts and perhaps the state courts in Arizona are going to be required to decide quickly, my criticism of the opinion does not relate to the result, but it is so open that it provides very little guidance to any lower courts that are going to decide that question. Now, the one thing I will say is that doesn't mean that lower courts are without guidance. In the Ninth Circuit, for example, Lauder versus Otter has been decided on more traditional grounds that don't really involve, at least as I read it, the interlocking analysis you suggest. And so I think I have a clear rationale to use in deciding some of those instances by the Ninth Circuit. But it is interesting that Obergefell, I don't think, vitiates any ground that any court has used to find a right to same-sex marriage, and those grounds, as I look at them, are different by the courts. And so I still think that we are in a period of experimentation. Maybe that's not a bad thing. We'll work through the courts on these, but courts are about picking winners and losers. And it does seem to me that even if the new analysis is an interlocking nature of due process and equal protection, and certainly equal protection has been suffering of late, it's still going to require identifying winners and losers, I think, in these questions. And I hope that that isn't going to simply be the product of an individual court's predilections, rather than some sort of principled legal guidance that will demonstrate the legitimacy of the decisions and help reinforce them. That's my comment.
So I think my overall take on this case is that obviously it's an important and historic decision, as you suggested in your opening remarks. It is an example of how what goes on in the courts interacts with what goes on in society more generally. There's no way this decision would have happened were it not for a changing public and also elite attitudes towards gays and lesbians over the 40 years or so since that early 1970s case that you mentioned. So I think there's action going on here beyond the Supreme Court itself and beyond even the people who are waiting in line to stand for oral arguments, though those people were certainly a part of what was happening. In terms of the decision itself, I think this is a case that got the correct result, but for the wrong reason. So briefly spend some time on both those points, why they had it wrong reasoning, but then also what I think a better approach might have been. So I agree with many of the reservations that the judge expressed about the majority opinion. The big problem with it is that it's very opaque and unclear about why this fits in with either due process or equal protection, and even more unclear about how the two of them fit together. So as a result, it's hard to say what the underlying rule or principle here is. It's not just that it's hard to say whether something like polygamy falls within or outside it, but it's even hard to articulate what the principle to begin with is, and you get a lot of strange anomalies. I don't have time to go over them all, but I'll just mention a couple. On the due process side, you have a situation where due process has been unhinged from what it was traditionally understood to be, that is to protect rights that are deeply rooted in American history or tradition, or perhaps in the Anglo-American legal tradition more generally. You have now a situation of right to same-sex marriage, which is a relatively new phenomenon, is elevated to a higher level of judicial protection than economic liberties, which are much more deeply rooted in the history and original meaning of the 14th Amendment and American legal tradition, yet under the court's current due process doctrine, which Kennedy does not challenge for the most part, they get almost no protection at all, whereas this much newer and more debatable right gets stronger protection. Also, the due process clause rights, at least the substantive ones, are usually considered to be about individual freedom, and to some extent, same-sex marriage is an example of that. It's people choosing on their own to get married, but same-sex marriage, as Kennedy recognizes, also has a number of state-granted benefits attached to it, such as various legal rights and tax benefits and the like, and those don't really fit into a due process clause framework very well. On the equal protection side, I may disagree slightly with what you said, which is that your position, I think, is that Kennedy has sort of exploded and gone away from the tiers of scrutiny approach where some kinds of discrimination get higher level scrutiny than others. I don't think that's the case. He hasn't said, well, we're not going to apply this, say, to racial or gender discrimination. Indeed, in other cases, Kennedy has been very insistent that we must apply strict scrutiny to all racial classifications, for example. Rather, what he's done is left that framework in place, but grafted another type of framework, less equal protection jurisprudence on top of it, and then not really made clear where the old framework still applies and where it does not. So that's yet another, I think, ambiguity in the majority opinion, and there are some other problems there as well. They don't have time before we get into, but basically it's kind of a big morass, and what's worse is that it's a morass that I think could easily have been avoided. There are several ways that it could have been avoided, each of which I think would have been better than what the court actually did. Here I'll just focus on one because it happens to have been the subject of an amicus brief that I co-authored with Andrew Koppelman of Northwestern University, a left of center law professor, almost as much of a hippie as Professor Marcus is, name's not Clay. Koppelman and I don't agree on very many things in constitutional law, but we do agree on this one, which is that the better path for this case would have been for the court to simply say that laws banning same-sex marriage discriminate on the basis of gender. They're subject to the same kind of heightened scrutiny that other forms of gender discrimination are, and therefore could have been struck down on that basis without addressing any complex and difficult issues about due process or about newfangled equal protection analysis. How is this a case of gender discrimination where it's quite simple? If there's a law that says same-sex marriage is forbidden, the judge and I, for example, could not get married. Why not? Because we're both men. But if I were a woman or he was, we could get married. So this is a case where our legal rights depend purely on our gender. Even if everything else about us was the same, if one of the fact that we're men and neither one of us is a woman, that determines our rights. So therefore, in a case where your legal rights are dependent on your sex, is a classic case of sex discrimination. Now you might say, well, both sexes are actually treated equally here because women are equally forbidden to marry women just as men are forbidden to marry men. But if that's the tack you take, then you have to say that laws banning interracial marriage don't really discriminate on the basis of race, because after all, in those laws, blacks are equally forbidden to marry whites, just as whites were forbidden to marry blacks. So there was a similar equality there, if you like. The fact of the matter is there is gender discrimination whenever a law says that your legal rights depend on your gender. For example, as the Ninth Circuit pointed out in a concurring opinion by Judge Berzon, if there were a law that said that women are only allowed to engage in business dealings with other women, it would not be constitutional just merely because the law also said that men are only allowed to make business arrangements with other men. That would be a kind of equality, but it would not be an absence of gender discrimination, and the same thing applies here. Now, I would add further that the court has said for decades since the 1970s that gender discrimination of any kind is subject to heightened scrutiny, including, by the way, in cases where it's not motivated by hostility towards a particular gender. The original case in which this was decided was Craig versus Bourne, where the state of Oklahoma had forbidden 18 to 20-year-old men, but not 18 to 20-year-old women from purchasing and possessing 3.2% beer. Nobody argued that this was because the state of Oklahoma had it in for men and really didn't like them, but it was still gender discrimination that was subject to heightened scrutiny, and the same thing would apply here. In the brief, we also explained why this approach has roots even in the history and original meaning of the 14th Amendment. It was widely recognized at the time that the amendment would apply to gender discriminatory laws. They thought at the time those such laws would still be upheld because they felt they weren't arbitrary but were based on real differences between men and women. But that's just a factual judgment, and when we make factual determinations in cases, we have to take account of new evidence that has emerged, which to make a long story short, strongly suggests that same-sex relationships can serve many of the same functions as opposite-sex ones, and therefore, while in the 1870s, based on factual knowledge that existed then, it might have been reasonable to say that discrimination in this area could be upheld. By 2015, indeed much earlier, this was no longer the case, just as in the 1870s, the Supreme Court upheld a law saying that women could not be lawyers on the basis of what they understood the factual evidence at the time to be. They thought that it was incompatible with being a wife and a mother. Today, we know that at least in many cases, that's not true, and the same thing is true, I think, with respect to gender discrimination in marriage. And obviously, had the case been decided this way, there would not have been difficulties and complexities about polygamy or indeed any of the other issues I think that you raised. There are several other pathways the case had been decided. You mentioned one. I think there was a good case for saying that there is a classification of sexual preference, which should also get heightened scrutiny for many of the same reasons that race or gender do. I think that would not have been completely unproblematic, but it would have been better if what the court actually did. So the bottom line, I think this is a historic decision. I agree that it's long overdue. I agree that decades from now, probably we won't remember the details of legal reasoning. Let's focus on the great victory for a just cause. But I do think the case could and should have been done better from a legal point of view as well. Thank you.
So just quickly, just to respond very briefly, for Professor Shulman, that's an extremely elegant and wonderfully articulated argument. There's zero chance that was going to prevail, though, because Kennedy laid the groundwork for this in Lawrence. And I don't think he would have, I mean, he was the only justice. He is the only justice that matters, as the judge says. And he laid the groundwork. He spelled out the terms of the analysis in Lawrence, and that's the way it was going to play out, however intellectually bereft or unprincipled it was. So I'm very grateful for that argument, for your contribution, but I think that the die was cast in 2003. That's my impression. Judge Snow, I encourage you to read Richard Posner's take on polygamy. It's vintage Posner, Law and Economics. His argument for distinguishing polygamy from same-sex marriage is quite wonderful. He says that there's an easy distinction, and it's this. Polygamy, the problem with polygamy is that traditionally a single man can marry many women. That decreases the population of marriage-eligible women for the rest of the men who are left out of this, and that's unfair. And so the poor men who can't compete have a reasonable basis, and hence the state can regulate. So you can decide if you're convinced by that. Let me just say.
Let me ask though, how does that relate? How does Posner's argument relate to Kennedy's argument?
I have absolutely no idea, and I don't care. I'm just pointing out that this is a wonderful, totally vintage, sort of early 1980s era Richard Posner Law and Economics view of this that I encourage you to read because it's so wonderful and so vintage. The final thing to say about this decision that I do want to say, and I say this with utmost respect and deference, Judge, and it's this. tough. You've got like tenure, you're an Article 3 judge, you can only be fired by being impeached. You have even more job security than I do as a tenured professor, which is saying a lot. That's your job. I mean, too bad if you're going to have to figure out ways to resolve these disputes. And I will point to two cases by way of reference. Number one, and this is the trite one, but it's one I think worth pointing out, Brown versus Board of Education. Brown didn't solve anything. For the until the Congress passed the 1964 Civil Rights Act, Brown was in shambles. Brown says that you can't deny black children the right to attend public school with white children. Well, that produces 9 years of litigation, 10 years of litigation, about whether the state has an obligation to permit black children to attend school with white children, or to make sure that black children attend school with white children in some rigorous way. So this was left to the lower court. The Supreme Court stayed out of this. It didn't take another school desegregation case, with the exception of the Little Rock, Arkansas one, until well after the 1964 Civil Rights Act was passed. Right, Brown 2, which only muddies the waters further. But Brown 1 doesn't resolve these problems. It creates these problems, and the lower court judges have to hash it out. And what you get is you get the greatest appellate judges in American history, John Brown. You get J. Skelly Wright, who wasn't an appellate judge, but a district judge, coming up with remarkably nuanced and thoughtful ways of resolving these problems. And I think that that is part of the design. And when there's this new doctrine, a new doctrine created that's so important like this one, that it's better for the court to leave it to the minds of the lower courts, the better trial judges and appellate judges, to hash out how these things apply. So I look forward to your resolution of these problems, because I think that's the point. The second thing, reference point, is a case that my students in the room will probably smile when I mention, because it's my obsession. That's the international shoe opinion for personal jurisdiction. That is the best example that mirrors what Justice Kennedy did in this case. International shoe is a masterpiece. It takes pieces of a doctrine that's not working, looks through all these precedents, assembles it into a new doctrine based upon principles that exist in the old cases but haven't been fully recognized as such. And that's what I think Justice Kennedy does here, and that's why I describe this decision as a masterpiece of doctrinal disposition, because what he does is he does what the great legal theorist Ronald Dworkin would say: find some narrative that connects all of these cases together in the most logical, convincing way. And I think he does that. Are there lots of questions to be decided? Absolutely. But I'm glad there are, and I'm glad that you're going to be doing it, because we now have to turn to the next case, and if the Supreme Court just followed Judge Snow, there would be nothing to discuss.
Very smooth.
That's, well, I won't disagree with that, Judge. So we do have some time for questions? Great, we have time for questions. Yes.
In looking through all the opinions and dissents as well, there's something that's present in great abundance, and there's one thing that's not present at all, and I was looking to get a comment or two on that. What is present throughout is Chief Justice Roberts' dissent, a lot of vitriol toward Lochner that doesn't seem to be connected to anything. And what's not present anywhere in the opinion is any mention of the Ninth Amendment, which doesn't really come up too often. I think Goldberg mentioned it in his Griswold concurrence, and we don't really see much of it anywhere. But given that this could have provided an opportunity for a beach to hold for the Ninth Amendment, does the absence of it anywhere in the opinion say anything about the court?
I think the Ninth Amendment could have been a possible hook for this, maybe a better one than due process, but there is still this problem that part of what we're talking about here is government-granted benefits, and it's hard to argue that government-granted benefits are rights retained by the people. Usually rights retained by the people are individual liberties. So the invocation of Lochner, I think, is interesting in that this is part of a long-running debate about Lochner, and that at least until recently, both liberals and conservatives have agreed that Lochner is awful, but they disagree about why. For liberals, Lochner is awful because it protects economic rights, which they think are terrible, but they're not against substantive due process rights inherently, whereas for many of the conservatives, the problem with Lochner is that it's substantive due process as opposed to real due process, and so they like to trot out Lochner every time they don't like modern substantive due process decisions like Roe versus Wade, or this one. I personally think that Wagner in some ways has too much of a bum rap, and that there is actually a good historical case that economic liberties, as well as some non-economic ones, were supposed to be protected by this clause as a matter of original meaning. I don't think that a substantive due process is some kind of an oxymoron once you recognize that the key words is of law rather than due process. And in the 19th century, there was a dominant view among legal experts, also among the public as well, that of law didn't just mean anything passed by the legislature. It meant law that was at least somewhat in accordance with natural rights and liberties, which sort of self-interested economic regulations like the one that we were talking about in the Raisin case don't qualify. Because all they do is just sort of benefit powerful interest groups at the expense of the general public. And you could argue it's water under the bridge, but we would walk, we might not go back on it, but at the very least, I think there's good justification for getting away from the practice of using Wagner as just sort of an all-purpose stick to beat our opponents with in constitutional law debates.
It does seem to me that the Supreme Court is probably rightly hesitant to invoke the Ninth Amendment as to anything. I mean, if there is a governmental entity that represents the people, I think the dissent makes the argument it's not the Supreme Court. Maybe it's your city council. Maybe, that's a lot closer relationship to the people with a direct election. Clearly, though, when that comes to recognized rights, that's not true. The difficulty then is, how is it that can we use the Ninth Amendment to justify anything that 5 of the Supreme Court justices feel like is a fundamental right? I think if you were going to see them invoke the Ninth Amendment as a justification for substantive due process rights, it wouldn't be called a substantive due process. It would be called Ninth Amendment rights. I think they crossed that bridge a long time ago. They're not going to do it. That's just my guess. They'll prove me wrong next term.
And I think that ship has long since sailed, right? And if it were an idea that was going to be resurrected, it would be deeply unlikely that it would be resurrected in a case involving a practice that government engaged in, but didn't necessarily have to engage. I mean, just governments have since the dawn of time been an authority that married people. But we could imagine governments getting entirely out of the business of marrying, and we wouldn't think that we were left with some paucity of liberty. We could still have our religious entity or our friends who got certified on the internet or somebody else marry us besides the clerk. And so it doesn't seem the best candidate for a resurrection of the Ninth Amendment argument.
Let's take one more question, then we'll move on to the next case. Yes, in the back.
I just want to ask, how significant is oral arguments before the court where you are capable of changing the predetermined opinion of a justice?
Judge, do you want to take a stab at that, since you hear oral arguments?
Two things. I heard Justice Thomas respond to a group of Truman scholars, and one of them asked him, why don't you ask any questions at oral argument? And he went back into his chambers, he got 3 cards, and he put all the briefs on the case he was currently working on, and he brought them in before the students, and he said, I've read every word of these briefs. There is nothing more I want to hear about them. There isn't anything more I need to know. He said, oral argument is a show. And he said, it doesn't mean it's worthless, but oral argument doesn't change anybody's opinion. Now, I was on the Arizona Court of Appeals for 6 years, and oral argument was a lot of fun. I can think of one time in 6 years that it changed my vote. It sometimes changed the way I approached a question and informed me about something. But the reality is, oral argument very rarely changes anybody's vote. And my personal bet is, and this leads a little bit into what Professor Marcus says, that in a case like this, I think Justice Kennedy kind of knew where he was going before the case started. I kind of thought, though, and I appreciate the logic of what you're saying, you set this up at Lawrence, but my prediction really was almost exactly what Professor Somin said. I thought that because of what he encountered in Windsor, he might go back and do an intermediate scrutiny analysis. But clearly wrong about that, and it certainly feeds into your question. I think oral argument can affect the nature and the analysis more than it affects the result.
Oral argument happens right before the justices go into conference. And in some respects, what's happening at oral argument isn't about the lawyer interacting with the justices so much as it is the justices interacting with one another through the litigant, right? The kinds of questions that they ask, the kinds of follow-ups that they ask, they're sending signals, they're throwing out softballs, they're asking rhetorical questions that do not represent their own views in order to try to give somebody the opportunity to combat them. I think it might serve a really helpful purpose in terms of getting 9 people to have a vigorous debate with litigants in front of them who are advocates for a particular position. And that's separate and apart from whether it decides the actual case for any individual justice.
Just very briefly, because I know the judge wants to jump in, I entirely agree that oral arguments rarely decide outcomes, though various Supreme Court justices and other judges have said that they have in fact at times changed their minds to oral arguments. I think that's very unlikely to happen in a high-profile case like this. But the oral arguments here can still have value in at least reviewing some of the justices' thinking to the rest of us who watch them. And in this instance, actually, it may well be that Justice Kennedy already thought out way back in Lawrence, as he said, what he was going to do. That's a possibility. But in the oral argument in the Windsor case, he actually did ask specifically about the gender discrimination issue, whether this was a gender classification. So I think he may have been more open to different possible approaches to this than perhaps you suggested, and certainly the gender issue was raised in the oral argument actually in Obergefell as well. It led to Adam Liptak of the New York Times writing a whole article about this, though as it turned out he was wrong to think that the case would turn on this. So I think there is value to the oral arguments in terms of what they show about the justice attitudes, in terms of getting them to confront different points of view, even if they rarely actually influence the outcomes of cases.
I think that's a good point, but the one additional comment I wanted to make, because some of you are law students and some of you may be practicing lawyers. I have had lawyers at oral argument when I said, why didn't you raise this before? Say, well, I saved it for oral argument. That is a horrible, horrible strategy. If you've got a good argument, brief it.
We could easily spend the rest of the afternoon on this case, but I think we should move on to our last case. I just want to pause for 1 second, just to thank our panelists again. We're really lucky. Professor Soman is one of the, if not the national expert on takings, property rights. He has a new book, The Grasping Hand, on the Kelo decision that has just come out, if any of you is interested. So I wanted to mention that. We're lucky Professor Anderson Jones is, if not the national expert on statutory interpretation. Certainly she's tied for the top. So to have her comment on King v. Burwell is just wonderful. And then in this last case, the Arizona case involving Arizona redistricting, Judge Snow actually wrote the lower court decision. And if you had to suffer through the majority dissenting decisions, in this case as I did, and then you read Judge Snow's straightforward, easy to read, and entirely logical decision, you appreciate his particular wisdom. So let's move on to the Arizona redistricting case. This will be the last case of the day. The great Supreme Court Justice Louis Brandeis famously coined the term laboratories of democracy to praise our federalist system for its capacity to experiment. In 2010, the equally great Jon Stewart, channeling Brandeis, labeled Arizona the meth lab of democracy. With the number of times that our beloved state produces Supreme Court litigation as a guide, then Stewart's comment is apt. To refer to just one subject matter, Arizona produces an unusual amount of elections law jurisprudence coming out of the Supreme Court. Arizona redistricting did not involve, or independent redistricting, let's call it Arizona redistricting. It did not involve the sort of issue that Stewart was referring to as meth lab comment. He had set his sights on SB 1070, our notorious show me your papers law, as well as the law requiring President Obama to produce his birth certificate. Rather, this case involves something much near and dear to Brandeis's heart, a state's experiment with a mechanism designed to produce more fair, less partisan electoral boundaries, one produced through direct democracy. In a 5-4 decision, the Supreme Court upheld Arizona's Brandeisian experiment. Every 10 years, states have to redraw boundaries for congressional and state legislative districts. How they do so is governed by Article 1, Section 4 of the United States Constitution. It provides as follows. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations. This elections clause creates a problem. State legislators are tempted to do one of two things when they draw legislative boundaries. First, they're tempted to redraw boundaries in a way that preserves their chances of re-election. They're tempted to create safe districts for themselves, sort of a self-dealing. And second, the majority party in the legislature is tempted to redraw boundaries to privilege its own parties, entrench its party's continued political dominance. So note what is missing here: an effort to redraw boundaries to maximize the chances that elections reflect the aggregate voter preferences. To give an example, Texas provides one from 2010. There, Barack Obama captured 44% of the vote, or at least in the 2008 election, and yet the 2010 plan was designed to produce 26 Republican-leaning districts and 10 Democratic-leaning ones. What results is a mess. Every redistricting cycle produces a lot of litigation. The 2010 cycle alone produced 190 lawsuits filed in 41 states. Eventually, 9 states' plans were drawn not by legislatures, as Article 1, Section 4 contemplates, but ultimately by courts. Arizona's redistricting history exemplifies this problem. A court overturned the 1971 plan for diluting the vote of Native Americans. The Department of Justice vetoed the 1981 plan, again for diluting the vote of Native Americans. The plan following the 1990 census took 3 years to craft due to gridlock in the state legislature, and also failed Department of Justice review for failure to protect the vote of minority populations. So what's to be done? Well, along with about a dozen other Western states, and following the lead of every single modern democracy in the entire world, save the United States, Arizona in 2000 took redistricting away from the state legislature and put it in the hands of an independent commission. It did so through Proposition 106, an initiative that 56% of us Arizonans voted for. Prop 106 created a 5-member redistricting commission. 2 of the members will be selected by the majority party and majority leadership in the state legislature, 2 selected by the minority leadership, from a list compiled by the Arizona Commission on Appellate Court Appointments. These 4 members will then select the 5th member also from this list. The 5th member could not be registered as a Republican or a Democrat. Prop 106 permits the governor to remove a commissioner, but only for something like gross misconduct, and only with the consent of 2/3 of the Arizona Senate. Now this plan is not perfect. The commission's redistricting has run into trouble. It did so in 2001 for failing to protect the Latino vote sufficiently. But in contrast to previous efforts, the plan was revised fairly quickly without as much storm and stress. In fact, the experience was good enough to encourage a similar initiative in California. But things got hairy after the 2010 census. A draft map suggested that several districts that had once been safe for Republicans would become competitive. In response, our governor, Jan Brewer, accused the 5th commissioner of a hidden Democratic bias. Governor Brewer and the Arizona Senate removed this commissioner on what the Arizona Supreme Court would suggest were trumped-up charges. The commissioner, in fact, sued, and the Supreme Court ruled in her favor, restoring her position. Once the map was finalized, several individual voters sued, alleging that the map favored Democrats over Republicans, that it was drawn with sort of partisan motivations. A 3-judge panel of federal judges ruled for the commission with a dissenting vote, holding that the map did not reflect partisan objectives, at least chiefly, and was instead drawn in large measure to meet then existing Voting Rights Act requirements that had subsequently been vitiated. So what came next was a whole enchilada. Enough of these lawsuits going after just one map. The Arizona State Legislature brought the case we'll discuss today, arguing that the commission itself is unconstitutional. If you can't just throw out the bathwater, you might as well throw out the baby too. Just get rid of both of them. I'll quote Article 1, Section 4 again. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. The people, through an initiative, are not the legislature, the Arizona State Legislature argued. Hence, the commission and all that it has done are unconstitutional. This is a usurpation of power vested by the Constitution in the state legislature, the group of people that meets in a particular building in Phoenix. A 3-judge panel, Judge Snow on the panel, ruled against the legislature. Judge Snow wrote the majority of the opinion. The legislature appealed, hoping that the Roberts Court's rightward turn in elections law jurisprudence would benefit it. Alas, the legislature's hopes were dashed. Justice Kennedy, he of initiative and proposition-drenched California, joined the 4 liberal justices to affirm. Now, aside from some preliminary skirmishing over standing an obscure federal statutory provision that I don't understand and so I won't talk about, this case boiled down to the meaning of the term legislature in Article 1, Section 4. Does legislature mean the state legislature itself, or can it mean any entity within the state that exercises legislative power? Justice Ginsburg, writing for the majority, opted for the latter. She started with the obligatory nod to founding-era dictionaries. They defined legislature ambiguously, she says, simply as the power that makes the laws. Justice Ginsburg then turned to the election clause's purpose. The founders included, as she suggests, to give Congress power to override state election rules, not to entrench the power of state legislatures. I think this might be a little bit suspect. Indeed, the founders were concerned with state legislators entrenching themselves through manipulated districting, hence Congress's power. Nowhere in the records of the Constitutional Convention, she insists, was there any concern with how states exercise their roles in redistricting. Beyond this, Justice Ginsburg's opinion contains little reasoning beyond an invocation of Brandeis's laboratories of democracy ideal. She defends Prop 106 against the charge that it hasn't been useful in protecting against partisanship. She invokes a couple of cases that trumpet federalism as a value the court should favor, an argument at odds, to my mind, with her excavation of the election clause's emphasis on congressional power and excavation itself that one might dispute. And she stresses the commission as a manifestation of popular sovereignty. This opinion, to be honest, is pretty sparse, and as such, it's vulnerable to Chief Justice Roberts' scathing criticism in his dissent. Chief Justice Roberts' dissent has what Justice Ginsburg's lacks. His originalist argument about the intended meaning of legislature in the Elections Clause is surely stronger. He notes that the Constitution uses the term legislature in a number of other places unambiguously to refer to the body itself, and not just the legislative power generically. But the Chief Justice's opinion lacks 2 things. One, it lacks, it doesn't seriously wrestle with a relevant precedent, and I'm going to let Judge Snow address that issue. But second, I think it lacks a theory informing judicial review. Chief Justice Roberts never really indicates why this case is so important. Aside from constitutional formalism, why is it so important to return redistricting power to the state legislature? Well, Justice Ginsburg's opinion does have a theory. A theory has to do with channels of political change. The great constitutional theorist John Hart Ely argued that courts should scrutinize legislation most strictly when it blocks the channels of political change. When those who have the power to make laws pass laws have entrenched their own power, then the foxes truly guard the henhouse. The American experience with state legislatures controlling redistricting does bear this out. Justice Ginsburg's opinion seems motivated by a concern to keep the channels of political change open. This is what the Independent Commission was designed to do, to take power over who gets elected or re-elected away from those who would benefit most directly from the exercise of this power. In theory, and there's some data to support this, although it's not the most robust set of data, the results of commission-driven redistricting should better reflect voter preferences. When a law keeps the channels of political change open, and when its negation would block those channels, then the justification for searching judicial review and ultimately negation are weakest. Absent a super clear statement in the Constitution that Arizonans' attempt to wrest the henhouse away from the foxes is unconstitutional, the court, following Brandesian logic, should defer. Okay, Judge Snow.
Thanks. I do appreciate Professor Marcus going to the trouble to read my opinion so he would know what I wanted to talk
I
about.
did that last night after dinner when the judge mentioned it.
And he didn't step on my toes. Let me just say that, like Professor Stoneman, I think that if the text is pretty plain, you follow the text. And the text here says, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. When I first read that text, which was the first thing I read when I was assigned to the panel, I thought, yeah, they might have a pretty good case, although, if you're looking at the text alone, it talks about the time, places, and manner of holding elections for representatives. That, in and of itself, does not refer to selecting electoral districts for the representatives. And so to go beyond that, you'd have to look at legislative history to come to some sort of a conclusion. And the other thing that I looked at, in addition to legislative history, or constitutional legislative history, because I like that, is I looked actually at the precedents of the Supreme Court. And I do agree, with all due respect to Chief Justice Roberts, I agree with Professor Marcus's analysis that he was very short. And I think, well, I won't characterize it any more than that. He was very short in dealing with the court's own precedent on that topic, which changed my view about how I had to decide this case when I read it. Let me just say that Arizona passed its constitution in 1912, and it's a very populist constitution. And that's because in the early 20th century, this country was having a populist reform movement, and in that populist reform movement, in addition to the initiative and a referendum that were placed in the Arizona Constitution as part of the legislative power recognized in the Constitution, Ohio passed referendum provisions, which allowed the people to veto any political act or any legislation passed by the legislature. So in that year, in the Ohio redistricted, the Ohio legislature redistricted, it went into the people, and the people rejected the redistricting done by their state legislature in a referendum. The Secretary of State recommended that the people's referendum rejecting the redistricting be null and void because the Constitution said that the redistricting would be done by the legislature. And the Ohio Supreme Court said, no, this is an act of legislation, and Ohio recognizes referendum as part of the legislative process, and because they do, the quote is, the referendum is part of the legislature's power, and for the purpose of the election clause does not bar treating the referendum as part of the legislative power for the purpose of the apportionment. And it doesn't do that where it is so ordained by the state constitution and the laws. That is the quote from the Hildebrandt case decided by the United States Supreme Court in 1916, and recognizing that because Ohio had adopted the referendum as part of its legislative power, that was the legislature for purposes of the elections clause. In 1932, the Supreme Court decided another case called Smiley versus Home, and in that case, the governor vetoed. It wasn't a referendum power, but the governor vetoed the legislature's reapportionment. And the Minnesota Supreme Court held that when a state legislature reapportions legislative districts, it's not engaged in legislative power. It's engaged in a special reapportionment power that's not legislative, given it by the United States Constitution. And the United States Supreme Court again rejected that soundly. Nothing in the Elections Clause attempted to endow the legislature of the state with power to enact laws in any manner other than that in which the Constitution of the state had provided that laws should be enacted. So in essence, the Supreme Court has indicated that whatever the legislative power of the state is, that is what the Elections Clause is referring to. Let me just say, as the author of the lower court opinion, I did appreciate Justice Ginsburg's grace in the number of times she said, we agree with the district court. That's a very nice little touch that made me like the opinion. But I was surprised when I read Chief Justice Roberts' dissent, which I think is certainly powerful, and certainly more powerful if you're going to talk about the term legislature alone, that he felt so little need to address the precedents of the court, the previous precedents of the court, and to be honest, I don't think he dealt with them fairly. He did, I think, in one paragraph, well, let me just say that one place he says, he calls Justice Ginsburg out, saying that her assertion are not supported by any text of the Constitution or any other relevant legal source. Well, I think what he's saying is that previous Supreme Court opinions on the matter are not a relevant legal source, which strikes me as somewhat odd. Later on in the dissent, he said he does acknowledge that Smiley and Hildebrandt stand for the proposition that legislature does not mean legislature. But he says, put simply, The state legislatures need not be exclusive in congressional districting, but neither may they be excluded. I think this is where he gets the closest to being fair in dealing with Smiley and Hildebrand. But he still does not address the underlying reasoning of Smiley and Hildebrand, which is a holding of the Supreme Court that it is the definition of the legislative power that should be applied in applying the Elections Clause and not meaning strictly the legislature itself. And if he wants to limit Smiley and Hildebrand in that way, then I would ask him what I asked the very intelligent lawyers for the Arizona legislature at oral argument when we decided the case initially. And that is, where do you draw the line? How far is the participation of the legislature involved if the legislature doesn't have to be involved and if a referendum can completely take out what they do? Because the Arizona legislative system is not completely bereft of legislative influence. Where do you draw the line? They didn't have an answer for that question. And apparently neither does Chief Justice Roberts, because he didn't try to put forth any, as far as I could see, principled distinction. What really this has made me reflect on a little bit is the view, which I think is championed by several justices of the Supreme Court, and it's one with which I have some sympathy, that when it comes to deciding what the Constitution means, they are less bound by stare decisis than they are with respect to statutory interpretation. And certainly, Chief Justice Roberts holds the same position as John Marshall or anybody else. And he has the prerogative to say what the Constitution means as one of 9 people in a definitive way. But is it really true that over approximately now 240 years of experience as a nation, we have encountered no problems and no matters that the founders didn't consider, upon which the wisdom of the Supreme Court ought to be consulted? And is it really true that we can be free to reject stare decisis when those who came up with the idea of the Arizona Independent Redistricting Commission presumably looked at Smiley and Hildebrand and decided that it provided a basis on which they could construct the exact construct they did, as well as the state of California, the state of Oregon, the state of Florida, and others that have done similar things? The simple fact of the matter is what the United States Supreme Court says is the law, and because it is the law and people rely on it, they take action based thereon. And if they do, then I think the Supreme Court should not be so cavalier in their dismissal of their own precedent. I think it negatively affects their own influence, their own authority, and calls into question that they are something other than a political institution. I must also say that I think the history in this case is pretty clear, and Justice Ginsburg is right about this. In the constitutional history, the debate over the Elections Clause was the fact that they reserved for the federal government the right to overturn what the state did anyway. That was what people were excited about. And it seems odd that in the name of protecting states' rights, you're really depriving states' rights and raising a question that they never considered. And so I think that, again, while I do believe that a text means something, the text doesn't always answer the question. And historical constructs are subject to modern manipulation in ways that I think suggest that we ought to give a little bit more deference to precedent, especially when we're going to reverse it. And of course, if they didn't reverse it, we won 5.
Okay. I think we're just fantastically lucky to have Judge Snow here to come talk about this case, which I've actually heard several commentators suggest might ultimately prove to be one of the most important of this term. And I'd actually prefer to give the audience more time to engage with him on it than listen to me, so I'm just going to throw out 2 quick things that I've been thinking about this case. One about the dissent, focused on Justice Scalia's willingness to chime in about the merits of this case, even after finding that the case lacked justiciability. And the second about the majority opinion, focused on how Justice Kennedy got persuaded to join the court's liberal rating with the 5th vote in this case. On the first of these, as Professor Marcus mentioned, there was a sub-fight happening in the case on the question of whether there was standing for the suit to be brought in the first instance. Justice Scalia, joined by Justice Thomas, asserts that when there are disputes between governmental branches or departments on this question of the allocation of political power, you just don't have a case or controversy under Article 2. The standing doctrine, he says, keeps the court minding its own business in these kinds of cases. And that means that when there's a separation of powers issue, the court has to have the question come to it in the context of a private lawsuit where there's a claim or defense that depends on the constitutional validity of the action of that governmental body, not a direct complaint from the governmental body itself. So then, having announced that he would dismiss the case because the state legislature lacked standing to sue, Justice Scalia goes on to opine about the substance of the case. Quote, "Normally, having arrived at that conclusion, I would express no opinion on the merits. In the present case, however, the majority's resolution of the merits question, that legislature means the people, is so outrageously wrong, so utterly devoid of textual or historic support, so flatly in contradiction of prior Supreme Court cases, so obviously the willful product of hostility to districting by state legislatures, that I cannot avoid adding my vote to the devastating dissent of the Chief Justice." I just wanted to point out that I think there is no small amount of irony that Justice Scalia claims to be super spooked by the risk of judicial meddling in matters that he thinks they're supposed to keep their hands out of, but he just can't keep himself from putting his hands into it in a sort of, I'd just like to chime in that you're crazy kind of way. And so I wanted to point out that in addition to the merits of this case, the justiciability subtext of this case is really interesting. I'm pretty sure that when I teach standing this next time around in my Structures of the Constitution class, we'll be thinking about this opinion. Second, this case, like so many that we have seen recently, gets to its 5-4 outcome by way of a swing vote for Justice Kennedy. And one question is what's motivating him in this case to join the liberals. The answer, I think, is surely multifaceted, but I wanted to point out for purposes of our discussion that one important piece of it is surely Kennedy's longstanding commitment to principles of federalism and states' rights. So it's true that this decision is at its core really a strong affirmation of direct democracy, but it's also, of course, a reaffirmation of the concept of state-specific experimentation on those direct democracy principles. So we see Justice Ginsburg's opinion actually sort of feeding Kennedy's preferences on that front, pointing out that that experimentation, this movement, has now reached 21 states for the initiative or direct lawmaking power, 18 states for adopting amendments to the state constitution. About a dozen states have experimented with redistricting commissions that have varying degrees of independence from the state legislatures. And I suspect that all of that looks a whole lot to Justice Kennedy like the states as laboratories or as meth laboratories. The idea is that this question of state sort of direct democracy mechanisms is, this is an opinion from Justice Ginsburg that allows for state experimentation, because there are all kinds of ways that a given state, meeting the specific needs of that state, could try to do the redistricting. And as Rick Hasen and other election law scholars chimed in about pretty immediately in the wake of this opinion, I think it is very much a pro-federalism opinion, in that it gives individual states a lot of opportunities to try different approaches that might improve the political problems or tackle situations that those states identify with their process. And that may well be a very big piece of what got Justice Kennedy on board that was attractive about the majority position to him here. It's consistent for sure with his position in a lot of other contexts that the states should get to structure things in the way that they choose. And I think that undercurrent is going to prove to be a part of a sort of wider pattern on Justice Kennedy's part.
I'm not an expert in this particular field, and I certainly don't have the sort of deep knowledge of this case that Judge Snow has. So I'd just like to make a few brief points. One is, it does seem to be just good common sense that the power of redistricting should not be in the hands of the very people most likely to abuse it. So it seems like the framework that Proposition 106 puts in place, and also the similar approach taken in the state of Nebraska, for example, that seemed to me to be make good sense, or at least to be better than simply leaving it in the hands of the legislature. But I worry very much that this is not, in fact, the approach embedded in the Constitution. One reason why I think it might not be is that the founding fathers were actually extremely suspicious of direct democracy of any kind. They believed that it creates an arena and license for ignorant voters to do stupid and biased things of various sorts. They thought that direct democracy was what undermined the democracies of the ancient world and led to their downfall, particularly Athens. And so I think it is very likely, at least if you're an originalist, that legislature means legislature, and that the founders and most other legal things at that time would have been very shocked to think, well, it could actually mean the people voting in a referendum. So that's not, that's not a legislature, that's a mob, like the ancient Athenian mob that we were trying to prevent. Now, I think the founders were right to be concerned about political ignorance. I've even written an entire book called Democracy and Political Ignorance, where I make that point. In many ways, it's actually an even more serious problem today than it was in the 18th century or in ancient Athens. On the other hand, the founders were probably wrong to think that political ignorance is more of a problem in legislative elections, more of a problem in direct democracy than it is in legislative elections. In some cases, actually, it might be less problematic in direct democracy because there the voters are voting on a single discrete question, at least most of the time. Whereas in a legislative election or a presidential election or a gubernatorial one, often there are many different complicated issues going on at the same time, and most ignorant voters have great difficulty keeping track of more than a small number of them. So I think also modern scholarship reveals that the founders took too negative a view of ancient Athens. If you're interested in this subject, Josiah Ober, political scientist in Classes, has two excellent books that he's published about this subject over the last few years. But although I have serious reservations about the founders' approach to this, I do think that it may very well be, if you're an originalist, which certainly not everybody is, it may well be that this is just an area where the founders made a mistake. But if you're an originalist, we may have to live with it. Now, I think Judge Snow raised an excellent point about maybe redistricting doesn't even come within the scope of the Elections Clause because it's not part of the time, place, or manner of holding elections. I think, I'm not certain about this, I haven't studied this, it's arguable that redistricting is part of the manner of holding elections, that certainly part of the manner is what people go where. Maybe it's even also part of the place. The place where you vote is often to be determined by where your district is, but again, I'm not certain about, I don't know that much about the history of these clauses. I think there's also another important question which even very committed originalists disagree about, which is if you have non-originalist precedent on the books that has been there for a long time and been relied upon, should you overrule it or not? I think that's the sort of question the court should perhaps confront in this case. We have this precedent that states like Arizona have relied on. Should we really pull the rug out from under them even if we think it's wrong according to the original meaning? I don't have a very compelling answer to that question, certainly not one that I can spell out in the next moment or two that I have. So I think I'll end here and merely stating this is an area where probably Chief Justice Roberts is right, at least as an original manner, but it's also an area where there was simply a mistake that the founders made. This is a blind spot in your vision. Whether we have to live with that blind spot or not, I think that's an interesting and difficult question.
Okay, well, great. We have 15 minutes left. So I'll invite questions and ask you, if at all possible, to keep them on the brief side so we can get through as many questions as possible. And if you want to ask about any of the cases or you have a contribution to make about any of the cases, this would be a wonderful time to do so. Chris Robertson and then Chris Katz.
Professor Someone's comments at the end were very provocative about the founders' concerns about direct democracy, and I think it'd be squarely relevant here if the redistricting was done by some huge, like everybody show up and let's make a plan on Tuesday, which was more analogous to the ancient Greeks. But here we actually had something that I wonder if anyone made the argument in the litigation that this was a second legislature. It was actually a special purpose legislature. It was not direct democracy. It happened to have been created through direct democracy, but it could have been created through the actual legislature.
Yeah, so it's an interesting point. I think it would be hard to argue that this is a second legislature as opposed to some sort of expert bureaucratic body with powers delegated by the people. I think much direct democracy isn't necessarily deciding each individual case point by point. It's often creating some sort of framework for future decisions. And I think the founders' approach is that they would have been suspicious of this effort as well. And by the way direct democracy worked in ancient Athens was not that all of the voters got together every time there was some issue decided. Often the voters would in fact appoint a board of experts or a board of generals. There's actually 10 annually elected generals in ancient Athens who did various things, like lead the Syracusan expedition, for example, which really did contribute to the downfall of Athens. But the concern about direct democracy was that often the voters made bad decisions about this, and critics of Athenian democracy, like Thucydides, Plato, and others, they said that, well, if the voters wanted the Syracusan expedition in the first place, this is a terrible, ridiculous decision caused of ignorance that led to the downfall of the city and all sorts of horrible things. So I'm not sure the framers would have been satisfied by that sort of argument. You might say, well, the framers were just wrong about this. They didn't think about the conflict of interest that the legislature had. They didn't think about how voter ignorance could be just as bad or even worse in regular elections. So I'm not defending their approach to these matters. I just think they would not have been satisfied by that. Whether that matters to you or not depends on whether you're an originalist, how you feel about the precedent, and other questions like that.
Chris?
It seems to me that almost all the justices, especially those in the dissent, often pontificate about how, well, if you don't like our decision, there's always the political process. You can work through it and solve it that way. Why do you think there wasn't as much concern for this would have restrained the power of the people to limit the authority of their government? I mean, this is, if the dissent was the majority, it's essentially saying, no, you, as the people, you cannot limit the authority of the state. Well, I mean, to me, it just seems like that's always their fallback. No, you can go and fix it through the process, and they fixed it through the process this time.
And I think that your question sort of gets to the major dissent, and then also the dissent that Professor Anderson-Jones was talking about, and that's Scalia's dissent, where he said there's no standing because really we just leave these things to the legislature to work out. And if you would have left this to the legislature to work out, what you would have had, I suppose, is an Arizona Supreme Court decision that says, no, legislature, you can't do the redistricting yourself, and the legislature would have said, we will do what we want, we're not going to fund an independent redistricting commission, and we are going to do the lines ourselves. And then the question would be, at least according to current precedent, a question of whether or not this is a Republican form of government. But that is a political question which the Supreme Court has deferred to Congress, so it would have been up to Congress whether or not they were going to seat the representatives from the state of Arizona. That's a pretty high-stakes game to be playing, really. And I don't know that Congress, if it was going to have any sort of conscience at all, would allow the legislature of the state of Arizona to deprive the people of something that they have enacted by their own constitution. But it is kind of an intriguing, I mean, I can't say it's completely meritless, Scalia's dissent, but what he suggests, I think, would lead to absolute political anarchy in the state of Arizona before he decided the question. And is that something he really wants to have happen? He may be absolutely right, but it strikes me as not exactly promoting responsible government within the states.
So there'd be a commission drafted plan and a legislature drafted plan at the same time, and
Well, yeah, I think so, except for I don't know how the
Which
independent...
elementary school do I go to? Oh.
And I'm not sure really how you could expect anything from the independent commissions plan, because that costs millions of dollars to do, and the legislature is not going to fund them. And so you would have something like a crayon, and they would say, well, this is our best guess, we'll do it this way.
Just briefly on the subject of Scalia's dissent, I think he's badly wrong to argue that there is no standing here, and it seems to me there are many situations where government entities have standing, and it's hard to think of a clearer case where they should have it than when the question is, does this entity have a very important power or not? I don't, on the other hand, think that he was necessarily wrong to say, well, it doesn't have standing, and I addressed the substantive issue anyway, because, of course, the majority of the court had addressed it, despite the fact that Scalia didn't want them to. So it makes sense to say, I don't think this issue should have been before the court to begin with, but since the court did decide to address it, I feel that I should express my views on it as well.
with a lot of adjectives.
Yes, I mean, he spends actually a lot of his opinion taking a body of precedent that suggests that there is standing in these circumstances. A series, the Coleman case from the 1930s squarely says that there is, and then trying to distinguish it away. So it's no surprise that he's only getting just the 2 votes on it. I think he wishes there was not standing in these circumstances, but there's a massive body of precedent that suggests that there
And I
is.
think a massive body of mostly correct precedent.
Can I just say that when you are the author of the lower court opinion, you get a filing from the Supreme Court, which I did not know, which tells you we're holding jurisdiction on this case and we've directed the parties to address the following issues. And when I saw that they had reinserted standing back in, I was really surprised, because I was surprised they took the case because I thought they followed their own precedent. But they haven't taken the case, so I thought that they, issued sort of a rather summary ruling, and they clearly didn't do that.
On the standing question, just 9 months ago, the Arizona Supreme Court decided one of the Obamacare state exchange cases on whether a minority of legislators could sue because it required a supermajority, and it relied very much on Coleman in finding standing for the legislators. I don't think they knew that there was going to be such a hot debate on whether Coleman had 4 votes or 5. Is there any legitimacy to Justice Scalia's position that it only has 4 votes and therefore has no presidential authority? B, I know at least 2 of you don't really practice in Arizona, but would that have much of an effect on what our state Supreme Court is doing following Coleman then?
Well, let me, if I can. The state has very few standing rules. In state courts, standing is much more broad than it is in federal courts. The state courts do not use the federal standard of standing. So the state court feels completely free. And I think there are all kinds of reasons why that's appropriate, because state courts are courts of general jurisdiction. And so the state court does not follow the federal court standing rules. And I'm not sure, Chief Justice Bales left, I'm not sure he would necessarily agree with how you characterized what they did, but I certainly agree with your characterization that they applied much broader rules in terms of standing, and they always will. And I think that makes sense too.
I think the majority opinion has the better of the Coleman analysis. It seems, if you read the two, it's actually surprising what a percentage of the majority opinion in the redistricting case of the Supreme Court is taken up tackling the standing question. It doesn't seem a fair fight. Justice Scalia has to work very, very, very hard to try to explain away Coleman as being more like a 4-4-1 decision than a 5-4 decision, which it's been recognized as.
And I think really in truth, and Justice Thomas would say it outright, I think Justice Scalia has said it at times, although he's retreated a little bit from the position, that's one of those stare decisis things. They think they got it, they think Coleman's wrong. And I think Justice Scalia laid out the reason why he thinks Coleman's wrong, and that is courts are supposed to decide disputes with individuals, not with governmental entities. And so on that basis, he thinks it's wrong.
Other questions about the redistricting case or any case that we've discussed today? Okay, well, it's been a long afternoon, but I'm hopeful and fruitful one to think back to the Raisin case. Thank you all very much for being our guests this afternoon. It's been really wonderful. We're so grateful. Thank you.
Thank you, Professor Marcus. Now there will be a reception in the lobby across the, I don't know if it's still raining.